system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher.
According to the law, as I give you in the jury charges, and the opinion you entertain of the evidence produced to you to the best of your skill and knowledge, without favor or affection to either party, provided you are not discharged from the consideration of this case, If so, say, I swear. I swear. Thank you. Please be seated. Ladies and gentlemen, you are now sworn jurors, and again, you shall not speak with anyone about this case, and all the rules that I'll tell you before you leave will be in a place. You're going to get tired of hearing me saying that, but I just want to remind you. I gave you my office phone number yesterday before you left so that you could give any family members that need to get you for an emergency. Please get comfortable. If anyone needs a comfort break, I will be looking at you, watching for you. You can make eye contact with me. You can make eye contact with any of my bailiffs, and just give me some kind of signal, and I'll say comfort break, and we will stop. Your comfort is the most important thing to me. So if you have any situation that you need to stop, just let us know. I meant to tell you last night before you left, you can bring drinks into the courtroom as long as they have a lid. So hot or cold, you can bring those. If we're in the middle of a trial, we have a witness here, and you get a cramp in your leg and you just need to stand up, you just feel free to stand up and stretch. If you get a cramp in your leg and you need us to stop, just make contact with the bailiffs, and I'll take a break. But feel free to stand up if you need to. Eddie, my bailiff, has given you pens and pads for your use during the trial. The first thing I want you to do is, on the top page of those pads, write your name. Now, if you'll write your name now on the very front page. And then if you decide to take notes, I want you to always start on the second page. The reason being is because we leave the notepads here during breaks and overnights, and I don't want you not to share your notes with anyone. You leave them in your seat, and so the only thing we can see is the top page with your name on it. It keeps it confidential. Let me give you a couple of directions about if you want to take notes. You may take notes if you wish, but you would start on the second page. If you decide to take notes, please don't let note-taking distract you from paying full attention to the evidence and the witnesses. You may not share or discuss your notes with anyone until you start deliberation at the end of this case. Your notes are not evidence. They are simply memory aids. They are not more important than your own impression or memory of what the evidence may have been. You may consider in your deliberation another juror's notes to refresh your memory. You should rely on your own memory of the proceedings. Don't be influenced by the notes of other jurors unless their notes help you in determining your own independent memory in deliberations. You must leave your notes in the jury room except when you are in the courtroom, and at the end of deliberations, they will be destroyed by Gwinnett County. You will not get a transcript of any witness that testifies in this trial. So you must remember, in the best way that works for you individually, what the witness says on the witness stand. I think that I saw y'all in your jury conference room. It's right next to my office. You will probably run into me crossing in the hall. My office is the one that has the tree of life. You probably walk by that I bought in Africa on my door. And I'll just say hey and try to, because I can't really talk to you either, just like the attorneys, unless it's about some situational that you need a break. Finally, let me talk to you about technology. There'll be videos, maybe in openings, there'll be videos in evidence, sometimes there's audios, and technology is not our friend. We are in the old building. We can't live with it, we can't live without it. So please be patient. Inevitably, there will be a technology glitch, and we'll have to call IT, and they'll have to come in and help us, because things freeze, and so just bear with us. Now I'm going to give you some preliminary jury charges. You'll hear these at the end, but I like to give some preliminary ones so you kind of have a framework before we get started on the trial. Before we start with the openings, I'm going to cover some basic principles of criminal law. I'm also going to explain my role, your role, and the lawyer's roles. Finally, I'm going to tell you how the trial will proceed, because many of you haven't served on a jury, you don't know what to expect. You've been selected and sworn to try the criminal case of State of Georgia versus David Booker, Miles Collins, Joshua Hewley. That's case number 22B 040724.
I'm sorry, it's Josiah Hewley.
Did I say Joshua? Thank you. Josiah Hewley. And it's Wednesday. Okay. You have been sworn to hear the case of State of Georgia, David Booker, Miles Collins, and Josiah Hewley. The Gwinnett County Grand Jury has indicted the defendants on count 1, felony murder, count 2, violation of Street Gang Terrorism and Prevention Act, count 3, violation of Street Gang Terrorist and Prevention Act, count 4, aggravated assault, count 5, violation of Street Gang Terrorism and Prevention Act, count 6, violation of Street Gang Terrorism and Prevention Act, count 7, felony murder, count 8, violation of Street Gang Terrorism and Prevention Act, count 9, violation of Street Gang Terrorism and Prevention Act, count 10, hijacking a motor vehicle, count 11, violation of Street Gang Terrorism and Prevention Act, count 12, violation of Street Gang Terrorism and Prevention Act, count 13, possession of a firearm during the commission of a felony, count 14, violation of Street Gang Terrorism and Prevention Act, count 15, violation of Street Gang Terrorism and Prevention Act. The defendants have pled not guilty. They deny every charge. The defendants are presumed to be innocent until proven guilty. The defendants begin this trial with a presumption of innocence in their favor, and that presumption stays with each one and cloaks him until it is overcome by the state with evidence that convinces you beyond a reasonable doubt that the defendant or defendants are guilty of the crimes charged. You may not convict a defendant of any crime unless each element of the crime is proved beyond a reasonable doubt. The burden of proof is on the state to prove every essential element of the crimes charged in this indictment beyond a reasonable doubt. The defendant has no burden of proof at all, and the burden never shifts to the defendant to prove his innocence. However, the state is not required to prove the guilt of the defendant, of any defendant, beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is a doubt based on a common sense, based on your common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which you can give a reason based on a consideration of the evidence or lack of evidence, a conflict in the evidence, or any combination of these. After considering all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must find the defendant for that charge not guilty. But if you have no reasonable doubt that exists on your mind about a defendant's guilt to any charge, then you may convict that defendant. If the state does not prove the defendant's guilt in any charge beyond a reasonable doubt, your duty would be to find the defendant not guilty. My role is to determine the law that applies to this case. Then I will instruct you on the law that you must apply to the facts in reaching a verdict. I'm giving you some of those instructions now. You'll hear them again. I'll give you much more detailed instructions about each charge at the end of the trial. You, the jury, have a very important role. You determine the facts of this case from the evidence presented, and then I give you the law to apply to those facts, and you, as the jurors, have the very important job of applying that law to the facts. Evidence is how a fact is proved or disproved. Evidence can be either testimonial, here in the witness box, or it can be by exhibits. Testimony is what you hear from people who take the witness stand and they swear to tell the truth. However, the questions that the lawyers ask the witnesses are not evidence. Exhibits are documents, photographs, and other physical items that are admitted during the trial. The object of this trial and your duty is to discover the truth. During the trial, I will admit evidence according to the rules of evidence that are the laws of Georgia that I have to apply to a piece of evidence. Those rules are designed to aid in discovering the truth by making sure you consider only the best and highest evidence. The lawyers are advocates for their clients, and they have a duty to represent their clients to the best of their ability. They must follow the rules of law, the rules of trial procedure, and the rules of evidence during the trial. They may make motions or objections if they believe that any rule is not being followed. What the lawyers say in making or responding to objections is not evidence. I will admit or I will exclude evidence according to the rules. If a lawyer makes an objection and I overrule it, that means the evidence is admitted and you may consider it. On the other hand, if a lawyer makes an objection and I sustain that objection, that means the evidence is excluded from the trial and you may not consider it. You should consider only testimony and only those exhibits that I admit. You should not assume or infer anything about the evidence for which I have excluded. If you happen to hear or see any evidence that I end up excluding from the trial, you must disregard it entirely in your deliberations and in arriving at your verdict. None of my decisions and none Nothing I say during this trial is evidence. My decisions and remarks do not mean that I favor or lean to one side or another in this case. I am only interested in seeing that this case is tried fairly based on the laws of the Constitution of the state of Georgia and the Constitution of the United States. Sometimes I need to deal with lawyers' motions or objections without you being present in the courtroom. So I will excuse you to the jury room. We try to limit such interruptions. We've had multiple days of things that either side think might come up, and so we've brought them before this week to try to get a ruling on those so that each side knows what's coming in. So we've done a lot of work on this case before Monday when you came in to try to whittle down what could or could not be brought. But inevitably, something's going to come up, and I'm going to say, I need you the jury to step out so that we can argue it. You are not in your presence until I make a ruling. Please be patient with us. A lot of times, like this morning, we were all here ready to start at 9, and there was a matter that both sides needed to take up, and it took, I think, about 5 or 7 minutes, and we did that before you came in this morning. The trial will proceed as follows. First, the attorneys may give what are called opening statements. No attorney is required to make an opening statement. Opening statements are not evidence. They are simply an introduction to the evidence, a preview or an outline of the expected evidence. The state goes first because they have the burden of proof. Then the defense attorneys, one or all three, may give opening statements. The second phase of the trial is evidence. That's when evidence will be presented and admitted or excluded. The third phase of the trial is the attorneys may give closing arguments or summations. They may discuss the law that applies to this case and how, because they will already know what I have ruled is the law on this case because we hold conferences about that before closings. So they may discuss the law with you that they know that I'm going to give you to apply to this case. They may point out evidence that they believe supports their position. What lawyers say in closing, just like in opening, not evidence. The goal of a closing argument of each one of the attorneys that may give one is to persuade you to decide the case in their favor. The fourth phase of the trial is I will explain to you the specific law that applies to this case. And it's called giving you jury charges. I will have met with both sides. They have proposed what charges, what that law they think applies. We will have had a conference, and I will make rulings of what law applies, and then I will read those to you. It is very important that you pay close attention during this trial. If at any time someone can't see something on the video, you can't hear a witness, let me know. I have had jurors that needed to come down in the well and get close. We'll replay a video so you can be up close and personal with it. Whatever you need to let me know. So if you can't hear or see anything, or somebody standing in your attorney standing in your way and you can't see a video, just let the bailiffs know, let me know, I'll be watching you, and I will make sure and adjust that. I want you to consider the evidence that you hear with an open mind. I want you to not reach any final conclusions until the trial is over, meaning evidence is closed. Do not jump to conclusions before all evidence is presented. At this time, the parties may choose to make opening statements before we begin the trial. Does the state wish to make an opening statement?
We did, Your Honor.
All right.
Bradley Coleman, 29 years old, Josiah 30. He was a teacher. He was a coach. He was a beloved friend. He was the father of a beautiful 4-year-old girl. And he's the son of Mr. and Mrs. Coleman, who are sitting right here. July 10th, 2022, the last face that he saw was his. Last thing that he felt was a bullet. It went through bone, brain, came out of his neck. The last breath that he took, choking on his own blood. Why? Because they wanted a car. July 10, 2022, just a little bit past noon, at the QT gas station at Peachtree Ford. Mr. Coleman took his Dodge Charger, pulled up to put air in his tire. The defendants, who are gang members, backed in right beside him. While Mr. Coleman was down by his rear tire putting it in, this man, Josiah Hewley, got out of the car and went into Mr. Coleman's car. What he didn't know was that another car had pulled up right behind him in order to put air in his tire. Josiah backed out, he hit that car. That gave Mr. Coleman time to get up, open the passenger side, and grab Mr. Hewley. Mr. Hewley dragged him out of the car, and during the struggle, put a gun to his head, shot and killed Bradley Coleman. While that was going on, this man, David Booker, jumped out of the other car that brought them there, came up with a gun to provide support. When the gunshot went down, they fled in the car driven by this man, Mr. Collins. Here's what it looks like. Mr. Coleman's car. The defendants. How do we know that it was these three? Because what the evidence is going to show you is that Josiah Hewley was the shooter, that David Booker provided armed support, and that Miles Collins drove them to the QT and away from the QT. The evidence is also going to show that these two members are part of the 9 Trey Bloods, a violent gang that is known for stealing cars, as well as sex, money, murder. How are we going to show that? Because you're going to see the gang evidence that ties these defendants to those violent gangs, you will see the gang evidence of David Booker, where he proudly proclaims 9 Trey Bloods, also known as Billy Badass. You're going to see other social media posts proudly proclaiming 9 Trey gangsters.
Okay, trying to dig up on your boat. Trying to get over that shit like that. And I'm going to make
You'll see the significance of the tattoos, including the ones not hidden behind bow ties or shirts zipped up. You're going to see it for David Booker. You're going to see Miles Collins.
Billy gang shit. Yeah, real Billy gang shit. But get what? I never get them street laws. Nigga, mind your business, get money, and shut the fuck up.
Facts, nigga. What the fuck you talking about?
You're going to see the gang evidence of Josiah Healy, the shooter, all over his body, and the hand signs, proudly proclaiming on social media his membership in a violent and deadly gang. You're going to see other evidence, too, that among the crimes of 9 Trey Bloods and sex, money, murder, they steal cars. And you're going to see the defendants, each and every one, has stolen cars before. Because of gang members. The cars were violent. On July 10th, 2022, they did it again. But this time, somebody had to die. And that was Bradley Coleman. The evidence is going to show that as they fled the scene, the car that they rented had its license plates captured on a license plate reader. Vehicle movements were tracked, showing that as that car fled the scene, they went back to their neighborhood. The owner was located, the car was a rental, and it was rented by David Booker and Miles Collins on July 8th, just 2 days before they murdered Bradley Coleman. You're going to see the cell phone evidence that received since the search warrant, showing that those photographs and those IDs came from their cell phones. You're going to see that David Booker provided his Georgia ID, but he wasn't 21. So Miles Collins provided his driver's license. John, next slide, please. Quick. Oh, I'm sorry. Can you go back to the slide? Yes, sir. Thanks. In addition, you're going to see the text between Miles Collins, his girlfriend Jamira Pledger, actually sent payment for that automobile. That's this defendant. You're going to see that this defendant, Mr. Booker, is the one that obtained the mandatory insurance for that automobile. You're also going to see that a few hours before, the night before, July 9th, Mr. Booker drove to a Texaco gas station, and we know that because the license plate reader captured the movement as they were driving around. And at that Texaco station, he was wearing the same sweatshirt, and he bought a blue COVID mask. Why is that become important? Well, on the day of the murder, when Bradley Coleman went to the QT to put air in his tires, the defendants pulled up, and then she saw Mr. Hewley got out of that Mercedes. He shot and he killed Mr. Coleman, and he jumped back in. But Mr. Hewley, as he dragged Mr. Coleman out, dropped the mask. You saw that Mr. Booker came up in support and that Mr. Hewley shot and killed Bradley Coleman. Mr. Booker rented the car, got the insurance, ran up with his gun in support. Mr. Collins provided the support by helping to rent the car, driving them to, helping them to escape. So here are the witnesses that you're going to hear through trial, because you're going to hear certain just groupings of witnesses. And the first set of witnesses that you're going to hear are going to be witnesses from the state that were actually at the scene, where they saw the scuffle, where they heard the car peeling off, where they gave statements to the police. And then you're going to hear from the police and the responding officers that came to the scene. Photographs are going to be admitted, and then other evidence, including the mask that Mr. Hewley dropped. And the way we know that Mr. Hewley dropped it is because the murderer's DNA was left at the scene on that mask. You're going to see what's called CSLI, which is cell site location information. You're going to hear about how every time you have your cell phone and you make a phone call, it attaches to the closest cell tower. And then you can literally track the movements from the neighborhood all the way up to the QT. You're also going to hear that if your phone is not making that phone call, that if you have an app on your phone, that there's something called data location. And what you're going to find is his DNA at the scene and digital DNA for every one of the defendants. As they came up from their neighborhood to the QT, where Mr. Coleman was killed, then left that area and went back to their neighborhood and immediately returned the car. But then it's going to get even deeper, because you're also going to hear from the expert witness that's going to come in here and tell you that the probability of statistics is 1 in like a quintillion. It's Mr. Hewley's DNA. You're going to hear from the cell site and digital forensic experts who are going to be able to track the cars, and more specifically the cell phones, and more specifically the defendant's cell phone, from their neighborhood up to the QT and back again, or their data. Then you're going to hear from the lead detective also, who come through the digital extractions from the phones when the phones were downloaded. Miles Collins, his girlfriend Jamar Pledger, David Booker, and Josiah Hewley. You're going to hear from gang experts who are going to tell you the purpose of gangs like nine trade, sex, money, murder. You're going to learn how we know that the defendants are associates and members of those gangs, and they're cooperative gangs, by the way. You're going to hear from other victims who've had their cars stolen. They're going to be able to testify because they weren't murdered. Then, you're going to see the certified prior felony convictions for the defendants. Throughout the trial, you're going to see other connections too. Like the sweatshirt at the Texaco, at the scene. Like text messages, right, just moments after the murder. I can't say it over the phone, but some shit just happened. You're going to see other connections too. On the cell phones, turning the car immediately after the murder. For these events, the defendants have been charged with felony murder for the aggravated assault of shooting Mr. Coleman individually and as parties to a crime. Then you're going to see 2 counts attached to that for violation of the Street Gang Terrorism Prevention Act, gang charges. And the gang charges are repetitive for each substantive count. One for participating in that kind of gang activity, and the other one is what you're going to hear from the experts is it's an expectation of gang members to do these things. For the gunshot, individually and as parties to a crime. Felony murder based on the hijacking of the motor vehicle, and gang charges attached to that. The substantive charge of hijacking the motor vehicle, and then possession of firearms during the commission of murder. The defendants are all represented by very good defense counsel. The evidence will not go unchallenged. You will hear cross-examination. I want you to listen carefully. Because cross-examination will sound like it's a college or something. Oh, when you go to the crime scene, you take photos. And when you take photos, you put them in markers. When you put them markers, you put them beside the important piece of metal. This will be cross-examination. But on the most, and it'll sound like it's a college or something, but on the most important elements, his DNA, his cell phone, his text, his data location, their memberships in the gangs. There's not going to be one cross-examination question that creates even a moment of hesitancy in your mind. And at the end of the day, I'm going to come back and I'm going to ask you to return a verdict of guilty because this county lost teacher, coach, father of a beautiful young lady, son, for a dead young car. Thank you.
Thank you, Mr. Melvin. Mr. Lewis, do you wish to make an opening statement
Yes, thank
for
you.
Mr. Booker? Excuse me, Mr. Lewis. During Mr. Melvin's opening, I heard some dings on a cell phone. There is a court order that everyone that comes into this courtroom have their cell phone off, not on silent, not on vibrate. And I will ban you from the court if I hear, or I will have my deputy take your cell phone if that disrupts any other proceedings. So make sure your phones are off.
Thank you, Judge.
Yes.
Good morning,
Hold on
ladies.
just a second. Hold on. We need a break? Okay. All right. We're going to take our morning break. And step back. I'm going to get high. Thank you. I need to get Hyatt in here. We're taking a morning break because the jurors needed it. Thanks. Sorry, Mr. Lewis.
No, it's no problem. Go ahead and start.
Do you have another quick share?
Yes, right here.
Thank you. John.
All
10
right.
minutes, Jeff?
10 minutes. Ladies and gentlemen that are in the courtroom, before you leave, everybody look at me. If you come in and out, those doors swing and they're very, very loud. and I want to make sure that each sides have fair trial. So you need to make sure that you hold those doors and they don't slam. And you are not to have your cell phone on unless you want to lose it to my deputy or be banned from the courtroom. So I just want you to understand that. You're welcome to be here, but you have to comport with my rules. Thank you.
Judge, how long? 5 minutes?
Let's say 10 minutes. I'm concerned about the loss of the juror with the dentist.
Yes, ma'am.
I'm sorry?
I'm concerned about the loss of the juror with the dentist appointment. She was
Oh.
crying. She was the one who asked for a break. She was crying. But
You do the dentist appointment or?
I Can I get a list of witnesses too?
Yes, ma'am. I'll have Armando.
Armando, do you have an extra copy? He's right there. Let's see. Just if you have an extra copy, or we can make it. Okay, thank you. All right. Thank you.
Yes, ma'am.
I appreciate it.
Yes, ma'am.
All right, they're ready? State ready?
Yes, ma'am.
Defense ready?
Yes, Judge.
All right. Thank you. All right. Mr. Lewis, I think we're ready. You do have an opening statement, I think. All right.
Good morning again, ladies and gentlemen. Opening statement is where the lawyers outline what the issues are to try to narrow your focus so that you, as you listen to the evidence, can sort of figure out what is it that I really need to be paying attention to ultimately and why. All of the lawyers are going to agree on certain facts. July 10th, 2022, there was a homicide. We're all going to agree on that. Outside of the courthouse, people interchange the words homicide and murder. Within the courthouse, the medical examiner is going to tell you homicide and murder aren't the same thing. Homicide means that one person has died at the hands of another person. In order for the homicide to become a murder, that it can't be accidental, there's no self-defense. So they're not quite the same thing inside the courthouse, even though they're the same thing outside the courthouse. And there's not going to be any argument from any of the lawyers that July 10th, 2022, there was a homicide. We all ultimately agree on that. We also don't really have any doubt about what occurred because it's captured on QT video, and there are witnesses who stayed around and told the police officers what they knew, and they're going to come in and testify. And what they're going to testify to is going to be basically corroborated by the QT video. Mr. Coleman came in. It appears that he's getting air in his tire because he's by the air machine. A vehicle that appears to be a Mercedes pulls in next to him. One of the occupants gets out. There's a struggle, and the person that initially gets out of the vehicle that's struggling with Mr. Coleman ultimately shoots Mr. Coleman. So there's not going to be any disagreement ultimately about what happened. Who shot Mr. Coleman? Ultimately, I think the evidence is going to show Josiah Hughley shot Mr. Coleman. I think the evidence is going to show that. So why is David Booker sitting here? Well, David Booker's sitting here because he has a connection to a Mercedes, and a Mercedes was used as the getaway vehicle at QT. That's ultimately why he's sitting here. So that's going to bring you, in regards to Mr. David Booker, to the first issue. The first issue that you have to decide. Is the Mercedes at the QT the same Mercedes that David Booker is associated with a day and a half earlier at the Texaco in Atlanta? David Booker has a connection to the Mercedes that you see, that you saw in the opening statement where they have the tag. That Mercedes is found in about a 1 mile radius of the QT. Here's where we get to the magical language. The state says that Mercedes is fleeing. So he puts the Mercedes that you have the tag for at the QT, but no one else does. There's not going to be any QT video that you look at where you can look and see that's the tag. None of the witnesses at the QT say, hey, I saw the tag or I saw a piece of the tag. None of that's going to happen. So this Mercedes that's half a mile or a mile away, it's not the traffic camera at the corner where the QT is. The Mercedes that's captured at some distance from the QT, the state says that's the Mercedes. And then from the statement, that's the Mercedes, they go backwards and say, that's why David Booker's involved. There's no one that's going to testify to the tag of the Mercedes that you saw on the flock camera. No video is going to show the tag to that Mercedes, but my client is associated with that Mercedes, and I suspect you're going to see evidence that he was at a Texaco about a day and a half earlier with that Mercedes, and I suspect there's going to be some evidence that he may have put some insurance ultimately on that Mercedes. So that's the first issue. Is the Mercedes that my client is associated with, is that the same Mercedes that was actually inside of the QT? And fleeing language, which is a conclusion, is not the same thing, ladies and gentlemen, as evidence. The second issue that you're going to have to decide as to David Booker is, was David Booker present at the scene of the QT at the time of the shooting? There's no witness that's going to come here that was at the QT at the time that's going to point and say, I saw David Booker. That's David Booker. He was present at the QT at the time of the shooting. There's no witness that's going to testify to that. The QT video that you saw in opening, that's all you can see. Some figures. You can't tell if they're men or women. Some figures. Clear what happens, but you can't see anyone's face. So there's no, slow it down, blow it up. You're never going to be able to see any face of anyone. So there's no video that's ultimately going to identify David Booker as being present at the scene of the QT. There's no fingerprint that's going to put him at the QT. There's no DNA evidence ultimately that's going to put him at the QT. He never admits to being at the QT. So we get back to, in terms of Mr. David Booker being present at the QT, we get into this fanciful new language. digital DNA, digital deoxyribonucleic acid. There's no such thing. That's just another made-up term. The prosecutor is hoping if you can buy into the digital DNA theory, that if my phone is in Tracy Drake's car, I'm in Tracy Drake's car. See, they can't put David Booker there at the QT, but his cell phone is pinging from an area that's around the QT, like the car is around. So we have a car and we have a cell phone that is associated with David Booker pinging in the area. And so the prosecutor says, oh, that Mercedes is the Mercedes fleeing. The digital evidence is pinging, therefore it's Mr. David Booker. If you type in digital DNA, nothing comes back because it's a made-up term. It's just made up. But that's the second issue, the made-up issue. The second issue is, can the state put Mr. David Booker ultimately at the scene, at the QT at the time of the shooting? So the first issue, you've already got a conclusion that the state has made, that the Mercedes is fleeing. And now you've got this made-up magical language, digital DNA, as it relates to the second issue with Mr. David Booker being present or not present at the QT. The third issue, obviously, is the gang charges. You should already know why, in opening my client on the video, that was actually longer than the QT video. You should be able to know that. He's hoping that he can prejudice you. The prosecutor's hoping that you'll look past his conclusions about fleeing and digital evidence and say he's not a good person. If you need to write that down, you can write it down. David Booker is not a good person. You're not here to decide that. You're here to decide if the state's evidence is enough for you to determine that David Booker is guilty beyond a reasonable doubt. It doesn't matter if he's guilty or not. I always tell jurors, it doesn't matter. I believe one of the good people in the world is Mother Teresa. If there's evidence that she has shoplifted something from Walmart, then you say guilty. You're not here to judge her. You can't tell me Mother Teresa's a bad person, but you can tell me that the state has proved her guilt beyond a reasonable doubt as to the shoplifting. We're not here to determine good or bad. We're here to determine if the evidence is enough. But we got to deal with the third issue, the 10 gang charges. Is Mr. Booker in a gang? I suspect the evidence is going to show that Mr. Booker's in a gang. I suspect the evidence is going to show Mr. Booker's not a good person. I'm not worried about you liking Mr. Booker. I'm not worried about that. I'm not going to be asking any questions to try to persuade you to like Mr. Booker. We don't need to leave this table. Is the evidence enough? Is the evidence enough? Whether Mr. Booker's in a gang or not, you still have to answer the second issue. Was Mr. Booker present at the QT, and what was his role for purposes of the gang charges? Did he participate in any type of criminal activity, robbery, theft, hijacking of a motor vehicle, in furtherance of increasing his status in the gang? So that's the third issue as it relates to David Booker. Issue number one is let's call it his Mercedes, even though you already know he doesn't own it. Is the Mercedes that he's insuring the same Mercedes that's at the QT? That's a big question mark. A big question mark. And I don't think the state's going to be able to provide you evidence to say yes, conclusively it is. Number two, is there any credible evidence that David Booker was present? Not his phone, not his girlfriend's phone, but actually David Booker there at the QT during the time of the shooting. And then number three, if he was there, if we get that far, do we believe that he was there acting in some capacity to furtherance his status in the gang activity? It's a circumstantial case, ladies and gentlemen. We know what happened. We got to try to figure out, after the shooter, did the other two gentlemen play any role in this whole thing? And that's why there's so many witnesses, and there's gonna be so much evidence, videos and things of that nature, because it is a circumstantial case. But I suspect that at the end of the case, there's not gonna be enough credible evidence to satisfy you. At the end of all of the evidence, after all the cross-examination, after you hear from the witnesses, after you see all the witnesses, I suspect that you're going to be left with some reasonable doubt as it relates to David Booker. And then I'm going to come back and I'm going to ask you to find David Booker not guilty of all the charges. Remember, it won't matter that he's not a good person or that he's in a gang. If you don't believe, I'm not sure that's the Mercedes. How do we know he's there again? What? And I'm going to expect you then to follow your oath and find David Booker not guilty of all the charges. Thank you very much. Thank you, Judge.
Thank you, Mr. Lewis. Mr. Clegg, do you have an opening on behalf of Mr. Collins?
Yes, Your Honor. Thank you very much.
Thank you.
Good morning, ladies and gentlemen. As I introduced myself to you yesterday, my name is Tom Clegg. I'm an attorney. I have been practicing law for, believe it or not, I guess 48 and a half years now. And I have the opportunity, well, first of all, I have the privilege of representing Mr. Miles Collins. Okay? I'm not going to stand up here and tell you that Miles Collins is not a good person. He is a good person. Okay? But I'm here to give you what is called an opening statement at this point. And as Mr. Lewis alluded to the fact, an opening statement is simply a coming attraction of what we expect the evidence to show. In closing argument, all of the attorneys will have the opportunity to stand up and try to connect one fact up with another and ask you to draw conclusions. I'm not asking you to draw conclusions. I'm simply here to discuss what it is that the evidence is going to show, and more importantly, what the evidence is not going to show in regard to Miles Collins. Understand, each of us, all three of the attorneys, represent our individual clients. I am here on behalf of Mr. Collins. I am not here on behalf of Mr. Hewlett. I am not here on behalf of Mr. Booker. I am not going to be attempting to assist the prosecution in convicting those two individuals, but I am here focused on Mr. Collins and what the state can show, and quite frankly, what the state cannot show. Now, there are essentially 45 counts of the indictment. You have heard 15 of them read. There are 15, but 15 times 3, because there are 3 defendants, is 45. So ultimately, in resolving this case, when you deliberate, you will have to issue a verdict 45 different times. That is going to require all of you to pay attention to all of the evidence that is elicited in this courtroom. All 3 of the attorneys, as well as the prosecutors, are experienced and have a pretty good idea of what we are doing. We will not be asking questions simply to play to the camera. We will be asking questions for a specific purpose. I am going to ask you to take notes, or at least pay very close attention during this course of the trial, because ultimately this case is going to be resolved based on the details and the evidence which is produced. Now let me say this up front. Bradley Coleman, the victim in this case, is an innocent victim. He was doing nothing wrong back on July the 10th of 2022. He was at a QuikTrip at about 12:38 in the afternoon on a nice sunny day, putting air in his tires. This is in Peachtree Corners, a relatively nice area of Gwinnett County. He was minding his own business. Someone attempted to steal his car. Because of a confluence of events, because things went wrong, somehow or another, that did not happen. He became aware of the fact that someone was attempting to steal his car. He sought to intervene. A struggle ensued, and he wound up being shot. He was shot 1 time. There was one individual who fired the shot, one individual who fired only that 1 shot. Again, I am not here to assist the prosecution, but I can tell you beyond all doubt, and this is even beyond the reasonable doubt, that my client, Miles Collins, had nothing to do with the actual shooting of Bradley Coleman. The state will introduce absolutely no evidence to suggest or even argue that he had anything to do with possessing a gun, with getting out of a car, or with firing a shot which killed the victim. Now, understand this. We expect the evidence is going to show that the intent of whoever was in the car was to steal another person's car, to get Mr. Coleman's car. Mr. Coleman was not in his car when whoever it is got into the car and attempted to drive it off. Mr. Coleman was in fact leaning down, putting air in his tires. We expect the evidence will show that originally he would have been unaware of the fact that someone was attempting to steal his car. No one, and the evidence is going to show this fairly conclusively, no one was intending to confront him with a gun. No one was attempting to take his car by force. What was intended was instead a surreptitious, a stealth act. Let's go ahead and steal this guy's car before he is even aware of it and drive off. Now, so you're going to have a number of questions you're going to have to resolve in this particular case. First off, who is it who's involved in the commission of these offenses? And secondly, if you are satisfied that any of the three defendants are involved, to what extent are they involved, and to what extent does their involvement make them guilty of the crimes with which they are charged? That's ultimately going to be the issues in the case. Now let's talk about the first category of issues first. How is it that they know that my client, Miles Collins, is guilty of the crimes with which he is charged? Mr. Lewis has already stood before you and basically told you you're going to hear certain things, you're not going to hear certain things. He is absolutely correct when he tells you that the bottom line is that the state of Georgia is not going to be able to conclusively demonstrate to you that the car that is seen in the video can be linked to any of these defendants. There is a car that can be linked to Mr. Booker and to Mr. Collins, but the bottom line is, can they demonstrate that that is the car involved in the commission of the crime? And again, you've seen the video. The video is not going to show the tag. There are going to be a number of people who are going to testify in this case. They were at the scene. They had an opportunity to observe the actions which occurred. They are not going to be able to identify the tag of this particular vehicle. Instead, the police are operating on certain assumptions that, quite frankly, this car must be the car that was involved. But quite frankly, ladies and gentlemen, when you deliberate amongst yourselves and determine whether or not the state has demonstrated beyond a reasonable doubt that these individuals were even involved to any extent whatsoever, you're going to have to do so. And to prove beyond a reasonable doubt does not mean they must have been the car involved. It means they actually have demonstrative proof that it was the car involved. Again, no eyewitness, no video at that scene is going to conclusively say this is the car that was involved. Okay? They are going to say we have seen the car in the area at other times, therefore this must be the car. More importantly, they're going to offer conclusions as to the number of people who were in the car. Those conclusions are probably fairly valid, okay? There must have been at least 3 people in the car that was attempting to steal the other car. There was a driver, there was the person who got out of the car and into the Charger, and then there was the other person who got out of the passenger side of the car and apparently attempted to intervene when things went south. You have seen the video. Again, as Mr. Lewis said, the video is not going to be able to make you able to draw any conclusion specifically as to the identity of the individuals. At no point during the course of this trial, at no point whatsoever, will anyone come into this courtroom, look at Miles Collins, be asked to identify him and say, was Miles Collins the person at the scene? No one will make that testimony. No one will make that identification. The conclusion of the state, it must be, will be that Miles Collins was the driver of the car. Listen to the testimony of the individuals who were present. Listen to what they say about whether or not they are able to offer an opinion as to the ethnicity, as to the sex, as to the age of the physical characteristics of the individual who was driving the car. There will be virtually nothing. The video will not show it. No individual will show it. There will be nothing to show that Miles Collins was at that scene. Is there any identification? The answer is pure and simple. No, there is not. Now, that's what they got. There will be an individual, there will be some testimony to suggest that someone was able to catch a glimpse of the tag. Although they were unable to get the tag number, they concluded it was from an out-of-state car. Okay? The car that the link to the defendants was rented from I will say a rental car agency, but it's not like Avis or Hertz. It's somebody who owned a couple of cars and had a relative go ahead or some friends go ahead and rent them kind of on the side. Okay? And the evidence will show that my client and Mr. Booker, in fact, did rent such a vehicle. That's it. Can they link that car conclusively to the scene? No. Now, the second issue you're going to have to resolve is what exactly transpired when things went south, because they clearly did. I mean, as I indicated to you, this was not an intent to cause anyone any sort of injury. You will be satisfied after hearing the evidence that whoever it was who was involved in the commission of this underlying offense did not intend to confront Mr. Coleman, did not intend to produce a firearm, did not intend to cause any sort of injury to him whatsoever. Instead, they wanted to get in the car, drive off, and get away. Because of the intervening facts, another individual having to pull his car in front of the car that was going to be stolen, that did not happen. That, and I think there was an actual collision between Mr. Coleman's Charger and his third car. That alerted Mr. Coleman, and Mr. Coleman, being aware of the fact of what was transpiring, went ahead and reacted. He is certainly entitled to react in that manner. As I have said, I am not suggesting in any way, shape, or form that Mr. Coleman is anything other than an innocent victim. He's put an air in his tires, for God's sake, at a QuikTrip in the middle of the afternoon. But the bottom line is, because there is that brief collision between these two vehicles, Mr. Coleman sees what's happening, gets into his car, and begins to struggle with the individual who is trying to steal his car. Mr. Coleman is not shot in his car. Mr. Coleman has a gun of his own. At some point, the evidence is going to show that Mr. Coleman, who carried that gun with him and had a holster for the gun, took that gun out of his holster. And in doing so, to some extent, upped the ante of the circumstances. The bottom line is, there was a struggle inside the car, but no shots were fired inside the car. At some point, one of the issues you will have to resolve amongst yourselves in deciding this case is who produced a gun first. Was it Mr. Coleman, or was it the individual who shot him? I am not sure you will be able to make a definitive decision in that regard. But there is no question Mr. Coleman had a gun. Now, the state stood up in its opening statement and suggested to you that whoever got into the car pulled Mr. Coleman out of the car and then summarily executed him. That's not what the evidence is going to show. Mr. Coleman was a big guy. He was an athlete, a former college athlete. He was still, I think he was under 30 years old, if memory serves. If he might have been 30, I think he was in his late 20s, but he was 6'5", at least 210 pounds at least. And you saw the picture of him seated there in the state's opening. He was an athletic guy. He was a strong guy. He had played college sports. He was not capable of being pulled out of the car. I believe the evidence is going to show that Mr. Coleman, when he got out of the car, after the struggle, was actually pursuing whoever had been in the car. Whoever got in the car, when confronted by Mr. Coleman, was trying to get away. He was trying to flee the scene. Mr. Coleman was trying to prevent him from fleeing the scene. Mr. Coleman was not dragged out of the car. Mr. Coleman got out of the car. Mr. Coleman had his gun, and then when they were outside of the automobile, the two individuals, one with a gun, Mr. Coleman, the other, the guy who got in the car, who happened to have a gun himself, wound up exhibiting the guns to each other, and a shot got fired. This was a non-intended act. Now, in ultimately deliberating this case, you will have to resolve certain issues. You will have to resolve amongst yourselves who is it who fired the shot. The state has stood up before you and said it's Mr. Hughley. I think the evidence is going to support that inference of the three. But the bottom line also, what you're going to have to decide is whether or not anyone else who was involved in the commission of that incident, of that intent to steal a car, is involved in the actual shooting of Mr. Coleman. You will be charged with the law on what is a party to a crime. But the bottom line is, this is a situation where because Mr. Coleman intervened, because Mr. Coleman happened to have a gun, because he interjected the gun, he wound up getting shot. Is that, under those circumstances, the unique circumstances of this case, enough for you to determine that anyone else involved in the commission of the events who did not actually get out of the car, who did not necessarily possess a gun, is guilty of a homicide? That's one of the issues you will have to decide. So the bottom line is, first off, you got to be satisfied that Miles Collins did something, that he was there, that he was identified at the scene. And secondly, you're going to have to be satisfied that he was in fact guilty of all of the crimes that are alleged. Now, there are the gang charges. Mr. Melvin, in his excellent opening statement, basically made reference to the fact that they are repetitive. I am presuming you all know that by now. It is tedious to listen to the indictment. You basically heard 10 counts when there are 2 gang charges. Who's fooling who? They were repeated 5 times each. They are identical. One of the things you will have to decide is this, wait to hear the evidence of the gang. I mean, are these guys members of a gang? I don't have a clue. But the bottom line is, they've got to connect up the fact that they are a member of a gang with the commission of these offenses. A number of the counts allege specifically that the offenses were done for the purpose of enhancing their position and status in the gang. Ask yourself, who is it exactly who's granting that status? Ask yourself, who is bestowing a position? Ask yourself specific details about the gang, about how they know this was a gang-related offense, any number of things, because you will hear from quote-unquote gang experts. These people are, quite frankly, deliberately vague. There's a gang, there's a crime, therefore it's a gang-related crime. You're going to have something more than that, ladies and gentlemen. So there are going to be a lot of details that you're going to have to pay attention to during the course of this trial. Okay? Some of you take notes, some of you don't. If you're taking notes, make sure to continue to listen while questions are being asked, and more importantly, while answers are being given, okay? You're going to have to pay attention to virtually everything that is said during the course of this trial. If you do so, and if you do so in the spirit of keeping an open mind and holding the state to their burden of proof, I am confident that at the conclusion of this trial, when I ask you to find Miles Collins not guilty of each and every one of the offenses that he is charged with, you will return a verdict pure and simple, consistent with that simple truth. The state of Georgia will make an attempt to convict Miles Collins. The state of Georgia ultimately will fail, and your verdict at the conclusion of your deliberations should reflect that simple fact. Thank you for your attention.
Thank you, Mr. Clegg. Ms. Drake, do you wish to make an opening statement on behalf of Mr. Hewley?
Yes, ma'am, thank you.
Good morning, ladies and gentlemen. Again, allow me to reintroduce myself. My name is Tracy Drake, and I have the privilege of representing Josiah Hughley. You may hear the state refer to him often, or witnesses, as the defendant. I, more times than not, are probably going to refer to him as Josiah. That's who I know him as, and that is what I call him. So I will be talking about Josiah. I wanted to go over just a couple of things before I get into my opening. I first off wanted to thank the judge about giving the warning about the technology issues. Not that I thought she was talking about me specifically, but she was talking about me specifically. It never fails. Every time I try to use technology, something goes wrong, but I'm getting a lot better at it. So hopefully it's going to be smooth this morning. Another thing that you may notice is that different times during the trial, members of defense counsel may be communicating with members of the prosecution. I assure you there's nothing strange going on about that. It may just be that we're trying to clear up an issue so that you don't have to keep going in and out of the room. So please do not think anything about that. You have heard from 3 separate attorneys. I'm going to try very hard not to reiterate things. However, some things need to be said more than once. And as you've already heard from 2 other defense attorneys, these 3 young men, even though they are being lumped together, and even though they are charged together, it's basically as if you were doing 3 separate trials. Mr. Clegg was correct. You are going to have to enter 45 different verdicts. Just because you enter a certain verdict on one charge does not in and of itself necessarily mean that all of the charges have to have that same verdict. So you are going to have to look at each verdict. This is actually, I believe, in my 20-something years, almost 30 years, that I've ever done a PowerPoint during the opening. The reason why I wanted to do a PowerPoint during opening is because, as Mr. Clegg and I believe Mr. Lewis said, when the indictment is read, it was very hard for me to even stay focused and follow. And I'm sure it was for you. My undergrad degrees are in middle grades math and science, so as a teacher, I like to accommodate everyone. Some people are visual learners, some people are auditory learners, some people like to feel things. It was kind of funny because my PowerPoint is going to be very similar in some respects to Mr. Melvin's PowerPoint. And I did warn him that I was going to mention his mother in my opening. She was a state teacher of the year and a national teacher of the year. So he comes by it honestly, because that is exactly something I would expect a teacher to do, is to try to explain things and break it down. So as you've already heard, you basically have 5 main charges with 2 gang charges that are attached to each of those separate crimes. But let's talk about, I want to explain these to you a little bit more so that you'll kind of know more of what you're looking for. Up to this point, everyone's just said felony murder based upon aggravated assault. But I want to show you a little bit more about what the indictment actually says so that you'll know some key points that you need to follow during the trial. So felony murder, which is in the first count, is cause the death in the commission of a felony, which is aggravated assault by shooting. That one seems pretty straightforward. The first gang charge is that Josiah was a member, which the state just told you that the evidence was going to show he was a member, not merely an associate, but was a member or associated with a criminal street gang, specifically the Bloods, and that they conducted and participated in criminal gang activity. And these are all things the state is going to have to prove to you in their evidence by committing felony murder. And as you've already been told, so I may go through some of these a little bit fast because I know that your time is valuable as well. The second gang charge, and again, these are all going to be the same for everything, is that basically the same thing, while being a member or associated with a gang, the Bloods, conducted and participated in criminal gang activity, in this case felony murder, with the intent to maintain, which means you have a current position, and increase his status and position. You will not hear any evidence about what Josiah's status is in a gang. You will hear zero evidence about what status allegedly was obtained or maintained after the incident that happened here. Aggravated assault. Make an assault with a deadly weapon by shooting. The state basically told you that the evidence is going to show that Josiah, and I'm just going to keep saying Josiah because that's what the state expects his evidence to show, that Josiah wanted to steal this car and that he shot Mr. Coleman because he was trying to steal the car. The evidence is not going to show that at all. What the evidence is going to show in regards to aggravated assault is that an individual got into the car. The evidence is going to show that it would have been impossible for, let's just say Josiah, to even see that Mr. Coleman was bent down beside the car. The evidence is further going to show that Mr. Coleman had a gun that was tucked into the back of his, I believe it was shorts. I may be mistaken, it may be pants, but in the back of his clothing that he had a gun. Only after there was a struggle in the car, only after a witness is going to tell you that there was yelling and a physical struggle outside of the car, was Mr. Coleman unfortunately shot and passed away. And again, the exact same gang charges specific to aggravated assault. Count 7 is felony murder based upon hijacking a motor vehicle. So what do you need to be looking for? That while they were in the commission of attempting to take, key thing that you need to be looking for is the evidence of by force while in the possession of a handgun. There's not going to be any evidence that control of the car was taken or attempted to be taken by force. No evidence of that whatsoever. No evidence whatsoever that a handgun by Josiah was ever shown, brandished in the car, or that was seen until right before the moment that Mr. Coleman was shot. And again, the 2 gang charges. And I'm not going to belabor that anymore since several of the other attorneys have already covered that. Hijacking a motor vehicle. Obviously, a Dodge Charger I know sometimes I will say Challenger because I'm like computers, I'm kind of car ignorant, but motor vehicle. Was it a car? Obviously, yes, there was a car. What you need to be looking for is, was it in Mr. Coleman's immediate presence? By force and violence, while with a gun, and the substantial steps. So you need to look for evidence of this. Pulled up beside Bradley Coleman and entered the vehicle. And again, the 2 gang charges. And then have during the commission of a felony, and they picked felony murder, not hijacking, but felony murder, had a firearm or a pistol. And again, you have the gang charges. As stated by, I believe, Mr. Lewis, what is this case about? Every death is not necessarily a homicide. Different terms. Every homicide is not necessarily a murder or a felony murder. Every crime is not because a gang does it. And every crime is not to maintain and increase one's status. That is what the state presented to you in their opening, but that is not what the evidence is going to show in this case. Not only do you need to pay attention to what the evidence is, but you need to take note of what the evidence is not, what the evidence does not show. Now, you saw this great picture that is supposedly Mr. Booker and Josiah. The evidence is going to show that is not Josiah in that picture. It is another conclusion that was mentioned to you, that it was Josiah. It was not Josiah. You are going to hear evidence about a struggle inside of the car. You are going to hear evidence that you could not see Mr. Coleman when you get into the car, based upon the positioning of the vehicles. You're going to hear evidence that Mr. Coleman had a gun on him while he was outside of the car. You're going to hear evidence that he was not in the car when allegedly Josiah got into the car. You're not going to hear from any of the witnesses that, other than the gun that the victim had, that they ever saw Josiah with a gun, and that when Mr. Coleman was shot, the only time a gun was seen was immediately before, and it was drawn from clothing. It was not like pointed down or somewhere else. It was drawn from clothing right before. You are going to see evidence of, as the state is alleging, Josiah was trying to leave. Everything was over, trying to leave and get away. And as pointed out by Mr. Clegg, you've seen Josiah, you've seen his size relative to me. You're going to hear evidence about the size of Mr. Coleman. And again, you're going to draw your own conclusions, but you're going to hear evidence that an individual, I'm wearing some kind of high heels, I don't know his exact size, pulled out a man who's an athlete, well over 6 feet, about 200 plus pounds. And you will be able to draw your own conclusions. Now, there is a lot more to go into. However, that is not proper during opening. That is just a preview of what the state's evidence will and will not be in this case. At the conclusion, we're going to be able to come back up here and kind of summarize what our arguments are. And we'll be able to argue the law to you and how you should apply it to the facts. I know that this is going to be a long trial. We are all going to try to make it go as quickly as possible, not to reiterate stuff, but it is very important to everyone the family of Mr. Coleman, the state, the defense attorneys, these 3 young men, that you listen. Details are very important. Conclusions that are proven are very important. And at the conclusion of the trial, I will come back up here and ask you to do what your oath and what the evidence demands in this case, is to find Josiah not guilty of the particular crimes that is in this indictment. Thank you.
Thank you, Ms. Drake. Ladies and gentlemen, today we're going to stop at 11:45. It is about 7 minutes till 11. Does everybody think they can go till 11:45 for their lunch break? Okay, so we won't take a break. State ready to call its first witness?
You are, Your Honor. The state would call Ms. Coleman.
Your Honor, may I approach with this?
Certainly. Thank you.
Thank you.
Ms. Coleman, will you please?
Your step. Standing and raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth in this case?
Yes, I do.
Thank you very much. Please be seated.
Good morning, Ms. Coleman. How are you?
I'm doing great, thank you.
For the record, could you state your name?
Sure, it's Venetia Coleman,
And could you spell your first name for the court reporter?
Benetia.
You live in Gwinnett County, Ms. Coleman?
Yes, I do.
How long have you lived here?
About 35 years.
And do you work?
I'm an educator. I have a daycare center.
How long you been doing that?
About 30 years.
Is that here in Gwinnett County too?
Yes, it is.
How many children do you have?
Currently, I have 1 child.
How many children have you had?
I've had 2,
Yes,
but
ma'am.
I only have 1 now since Bradley has been taken away from us.
Do you know Bradley Lamar Coleman?
Yes, that's my son.
Where did he used to live in 2022?
In 2022, he resided in New Orleans
Did he ever use your address?
all the time.
Did Mr. Coleman have any children?
Yes, he did.
Could you tell us about her?
He had 1 daughter. Her name is Amira Giselle Guillory Coleman, and right now she's 8 years old. But when this happened, she was 5 years old.
I'm going to show you what's previously been marked as State's Exhibit Number 1, previously shown to the Defense Counsel. You recognize Stage 1?
Yes, I do.
How do you recognize Stage 1?
That's my son.
Your Honor, we would consider Stage 1 this time. No objection, Judge. No objection, Your Honor.
No objection.
State's Exhibit 1 is admitted without objection.
Permission to publish?
Certainly.
John, would you publish Stage 1, please? Now I'm going to show your attention. When was that photo taken, more or less?
A few years, I believe, before he passed away.
Bradley looks kind of tall. How tall was he?
He was 6'9", but he was slender built.
Did he play sports?
Yes, he played football in high school and college.
What college?
He went to Southern University.
Let me ask you a couple of questions about Bradley's lifestyle. In July of 2022, was he visiting you here in Gwinnett County?
Yes, he was.
Can you tell us about that?
Yeah, he would often bring his daughter home to visit my husband and I because Bradley wasn't married, and he would always say, Mom, you and Dad were great parents to me. And he said, right now I don't have an example for that for my daughter. So it's important for me to bring her around people that are working, that are building together, that's been together for over 40 years. He wanted this stability for his daughter, but at that time he wasn't married, but he wanted to show his daughter the same type of lifestyle that he had.
So July of 2022, he was staying with you?
Pardon me?
Was he staying with you July of 2022?
Yes, he was visiting, yes.
When he visited with you, at the time, did he own a firearm?
Yes, he did.
I'm going to show you what's been previously marked as State's Exhibit Number 2. You recognize States 2?
Yes, I do.
How do you recognize it?
That's Bradley's gun.
Your Honor, we were to states to it this time.
No objection, Your Honor.
No objection.
Okay, States 2 is admitted without objection.
Permission to publish?
Yes, sir.
John, would you publish States 2? Is that the photograph of States 2 that you just testified to?
Yes, it is.
No, Smith & Wesson, Miss Coleman?
I'm not sure the brand, but I do know it's a 9mm.
Okay. Thank you, John. Did Bradley carry that firearm with him when he would leave from your house sometimes?
Yes, sometimes he would.
Okay. Let's talk about the day. July 10th, 2022. Did anything happen to Bradley on that day?
Yes, he was murdered on that day.
Your Honor, I'm going to object to the use of the word murder. That's the legal conclusion.
He was shot and killed
Okay.
that day.
When they object, we're going to...
Oh, I'm sorry.
Yeah, sorry.
Hold on just a second. Mr. Miller?
Judge will ask Ms. Coleman to use a different word.
Okay, so sustained. If you, Ms. Coleman, if you'll ask the question again, Mr. Melvin, and then you can answer. Thank you.
Okay, no problem.
Thank you.
It's okay. July 10th, 2022. What happened to your son?
He was taken away from us.
Was he killed?
Yes, he was.
How'd you find out, Ms. Coleman?
We received a call from a detective. We didn't recognize the call. The call came in 3 times. I told my husband, go ahead and pick it up because it may be something important. Had no idea it was a detective and he wanted to meet with us in our home. And when we met with him, he told us that Bradley was involved in a shooting. And at that time, I didn't have any idea that he was going to tell us that our son was deceased. And he said, Mr. and Mrs. Coleman, I'm sorry to inform you that your son did not survive the gunshot wound.
Was Bradley a violent person?
No, he was a loving person.
How old was he when he passed?
He was 29 years old.
He was taking care of his daughter.
Yes, he was an awesome father.
Who's taking care of his daughter now?
Her mother and my husband and I.
Thank you, John. Defense counsel will have some questions.
Mr. Lewis?
Good morning.
Sorry we have to meet under these circumstances. Obviously, your testimony was that you were aware that your son carried a firearm. Is that fair to say?
Yes,
How often, to your knowledge, would he carry a firearm?
sometimes.
Would you say 50% of the time?
I have no idea.
Fair enough. Bradley's vehicle, was his vehicle ever returned to you?
After he passed away, the detective called us and told us we could pick it up from the Savage Yard, but we called the finance company and had them to pick it up.
So after your son was shot and killed, you never again saw his vehicle or?
Oh, I saw it. We went to the Savage Yard
Okay.
and got his remaining things out of it, and we had the finance company to pick it up.
And that's my real question. When you retrieved all of Bradley's things out of the vehicle, at no point in time did you ever find his firearm. Is that fair to say?
That's correct.
Did law enforcement ever tell you in and around July 10th of 2022 that they had located his firearm? Up until today, has anyone in the district attorney's office or law enforcement ever informed you that they located your son's firearm?
Not to my knowledge.
Thank you very much, ma'am. No further questions.
Mr. Clegg?
Yes, thank you. Coleman, allow me to express my condolences for the death of your son.
Thank you.
Your son had a gun, correct?
Pardon me?
Your son had a gun, correct?
Yes.
How long had he had that gun?
I have no idea.
And if you could,
I have no idea. I'm not sure.
fair enough. He actually lived in New Orleans, correct?
Yes.
And at the time, back on July 10th of 2022, he was visiting Gwinnett County, correct?
Correct.
How long had he been in Gwinnett County at the time he was shot?
He had came and stayed for a couple of days and brought his daughter. And then he left and went back. And I believe 1 or 2 days before he was shot, he returned back.
And did he bring his gun with him when he came from New Orleans?
I'm sure he did, yes.
Did Did he drive or did he fly?
He drove.
I'm presuming he would have driven the truck, correct?
Correct.
Now, we have seen a photograph stations at the number 2 of that firearm. You described it as a 9mm, correct?
Yes.
And that was the gun that you recognized to be your son, correct?
Yes.
Do you know, and if you don't, that's fine, but do you know where it is that that photograph was taken?
No.
Do you know when that photograph was taken?
Do I know when the photo?
Yes. If you don't, that's perfectly fine.
Do I know what? Wait, say that again. I'm sorry.
The photograph, I'm going to put that in the photograph stations at the number 2 of the gun.
Uh-huh.
Do you know when that photograph was taken?
I don't know when the photograph was taken. No.
When you came back from New Orleans for that brief period of time prior to his being shot, had you seen the gun?
No.
But you did know him to carry the gun.
Yes.
Normally, he did not bring the gun, or do you know if he had brought the gun into the house, your house?
I'm sure he did because when he would bring it, he would always bring it in the house and he would carry it.
Was there a holster that was associated with it?
Yes.
Now, this is going to be a silly question, but just so we're all on the same page. A holster is something you put the gun in, right?
Correct.
Would you have at some point seen the gun in the holster?
I don't recall.
When your son would go out, would he take the gun with him?
Sometime he would.
And would he have the gun in the holster, or would he remove the gun from
I'm not sure.
Did you ever know him to carry the gun on his person when he got out of his car?
Say that again?
When he got out of his car?
Mm-hmm.
Did you ever know him to have the gun on his person?
On his person?
Yes. He physically carried the gun with him.
Oh, yes.
So he wouldn't leave the gun typically in the car. He would get out of the car and have the gun with him.
Correct.
Where exactly, if you know, would he carry the gun? Would it be on his belt?
Oh, I don't know where he would carry the gun. I don't know.
Do you know of your own knowledge whether he would keep the gun loaded?
I have no idea.
Did you ever pick up or examine the gun yourself?
Absolutely not.
Did you ever ask him about the gun?
No, I have not.
So you would never have asked him why it was necessary for him to carry the gun, correct?
Excuse me. He did express to me. I have to take that answer back. He did express to me that he had bought a gun, and the reason he had bought a gun for his protection. He did tell me that.
When did he tell you that?
I'm not sure when, but he did. I had that conversation with him.
Now, your son was a good athlete, correct?
When he played college football and basketball, yes. He in high school ball, yes.
He played both sports in college?
Yes. No, in college he only played football. In high school he played basketball and football.
When he was in college playing football, do you recall what position he would have played?
He was a receiver. A receiver.
Okay, you said he was, I believe, 6'9", is that?
Yes. Slender built.
So he's a tall guy, right?
Yes.
And he is a strong individual, correct?
He was slender built. Slender built. I don't know his strength.
Okay. All right. Did he ever tell you anything about practicing shooting the firearm?
No.
Do you know what a safety of a gun is?
No, I don't.
Fair enough, ma'am. Did you ever see any ammunition for the gun?
No.
Do you know what a clip is for a gun?
I know what a clip is.
Clip is what goes in the butt of a
Mhm.
correct?
Yes, I know what a clip is.
Did you ever see an actual clip that he inserted in
I don't recall.
on the occasions when you would have seen it? Would the clip have been in the gun?
I don't recall.
Do you recall what time he would have left your home on the morning of, or the early afternoon of July the 10th of 2022?
I'm not sure exactly what time it was, but I believe it was early, late morning, if I'm not mistaken. I don't know. I really don't know.
Do you recall how long he would have been gone from your home when you received the phone call indicating that he had been shot?
Well, when we got the call, it probably was around 3-something, if I'm not mistaken.
His daughter, did his daughter live here in the Atlanta area, or did she live in New Orleans with him?
She lived in New Orleans with him.
And was he with the woman at the time who was the mother of the child as well?
No, they were not together. They were co-parenting.
Gotcha. Okay, but did she live in New Orleans?
Yes, she did.
All right. I don't think I have any other questions. Thank you so much.
Mr.
Thank you so much. I appreciate that.
Mr. Melvin?
No indirect, Your Honor.
Okay. May we release this witness?
We would ask that you release. No objection, Judge.
No objection whatsoever, Your Honor.
No objection.
Okay. Thank you. Ms. Coleman, you may
Thank you.
step down and you can stay in the courtroom.
Okay, thank you so much.
State want to call its next witness?
Yes, Your Honor. Prior to that, a couple of housekeeping, Your Honor. We filed for business record exceptions for a 911 recording and for the QuikTrip videos. Pursuant to that, we've asked the States 5, which is the 911 recording, and States 21, which is the QuikTrip video, be admitted.
The business records certificates?
Yes, Your Honor.
Okay.
Pursuant to that.
Okay.
I didn't understand. I'm sorry.
I'm not sure. I think,
The actual items, pardon me. The certificate allows for the items to be admitted.
okay, we need to admit the certificates.
I think so.
Yeah, the certificates need to be admitted. Are you asking to admit the QT video as States Exhibit 3, and maybe the QT business record as States Exhibit 3A? Mr. Melvin, is that right? Okay? Okay.
I have no objection to that, Judge.
Okay. 3 would be the QT video, and 3A would be the States Exhibit 3A would be the business records certificate for the QT video. Okay, Ms. Drake. Okay, so I'm going to admit States Exhibit 3 and States Exhibit 3A as tendered. Now we're going to move to the 911 call. I would like to, the 911 call itself is it labeled Exhibit 5?
Yes, Your Honor.
Okay, then I'm going to suggest, if it's okay with Mr. Melvin, that we mark the business certificate as States Exhibit 5A.
Yes, ma'am.
Okay. All right, and so those are both tendered by the state. No objection from Mr. Lawrence. Mr. Lewis?
No, ma'am.
Okay, so I'm going to admit Exhibit 5, which is the 911 call, and Exhibit 5A as tendered, without objection.
Thank you, Your Honor.
Sure.
The state calls Paige Smith.
Okay, and if you would make sure the business certificates are placed on my bench.
Yes, Your Honor.
Right now, so we have those. That's 3A and 5A. Mr. Williams. Good morning. If you'll remain standing and raise your right hand. Do you swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please be seated. Ms. Smith, correct?
Correct.
My court reporter's taken everything down, and so the attorney's going to ask you some questions. If you'll wait till they finish the questions to answer, so that two people aren't talking, because you can't take down if two people are talking. And she unfortunately does not have eyes in the back of her head or a camera to see if you're nodding or shaking your head no. And if you say I may say, is that a yes? Because we're just trying to get a really perfect record, okay?
I understand.
All right, thank you so much. Go ahead, Mr. Williams.
And the witness has been sworn? Or,
I swore her.
thank you so much, Judge. Please tell us your name for the record.
Andrea Page Smith.
And where do you work?
I work at the U.S. Government Accountability Office, which is an independent, nonpartisan agency that works for Congress.
Now, do you remember the incident that you're here for, the incident that happened at the QT at the forum?
Definitely. It was very memorable. When somebody's murdered and you're that close to it.
Response?
If you could...
No, response to me. You want her to rephrase?
Yes, please.
Okay. Is it Miss Smith or Miss?
Miss Smith.
Yeah, okay, Miss Smith. Yeah, I want to make sure. Miss Smith, if you will not use that word, that's a legal conclusion in any of your answers. So you want to ask another question? Thank you.
Oh, thank you. Why were you at that gas station?
So I was in that part of town because earlier that day I had gone to a nearby church. And after church, I'd gone to the Trader Joe's and then to the gas station.
And what happened?
So while I was at one of the pumps on the outside row, I was getting my receipt and I heard from behind me the sound of screeching tires and a collision. And so I looked behind me to see what was going on, and I saw men struggling near a parked car. I saw one man pull another man out of the car. And it was about that time, so I was trying to figure out what was really going on, that I heard another customer or somebody else at the gas station yell out about there being a gun. So it was at that point that I hid behind my car. And while I was behind my car, I heard a gunshot go off.
Ms. Smith, I'm going to publish a still from a video that's already in evidence.
Okay.
Your Honor, may I publish States 21?
States 21?
Yes, Your Honor. Oh,
No,
sorry.
21 is not in evidence, Mr.
States
Williams.
3. States 3, sorry.
State 3 is a QT video.
Yes, Your Honor.
And it's a photo from that video. Is the state representing that, Mr. Melvin?
That is going to be the actual portion of the video.
It's not going to be a photograph.
No, we're going to start at 12:34.
Okay. Thank you, Mr. Melvin.
Ms. Smith,
You have a monitor right here you can watch right over here. And Mr. Williams may ask you to step off and point. Just there's 2 steps coming off the platform, don't fall. But otherwise, you can watch it right here. Okay? Go ahead, Mr. Williams.
thank you, Your Honor. Could you tell us whereabouts on either image you were positioned?
This is my car in the bottom right of the lower.
Maybe if you could step down, Ms. Smith.
Careful.
Okay. And can you tell us is the gas pump where would that be located?
So we can't see the gas pump in that video. Okay, thank you.
Okay. Now we're going to publish the video, Your Honor, and if you could just watch it for us, Ms. Smith.
The video?
Yes.
Okay, you can watch it right.
We're going to play it. Is that you getting out of the vehicle?
That's me, yes.
Why did you back up there?
I don't remember exactly, but that's a rental car, and so I imagine I parked too far away for the pump to extend. It wasn't my car that I normally drive.
Filling up at that point?
I think so. And I think I must not have wanted to step over the pump for whatever I was doing, so I took the long way around. Probably at this point, I was already hidden sort of behind the back of my car, right down here.
Yes, please.
I was back to the back of my car, hiding down here.
Did you see any weapons yourself, Miss Smith?
I did not. I just heard somebody say that they had seen a gun and heard the gunshot from behind the car.
Thank you, Your Honor. What did you see and hear?
So I did see the struggle near the car that I talked about. I heard somebody warn about a gun. So I did hear the gunshot from behind the car. And that's pretty much, I waited behind my car for a while until it felt like it was safe to come out.
Any tire noises?
I think that that's what first got my attention, was the sound of like screeching tires, a collision. That's what caused me to turn around in the first place from the pump.
What did you see when you came up from behind the car?
So just the back end of a car leaving the gas station.
Did you see anything else on the ground?
The poor man who had been killed was lying there on the ground.
Ms. Smith, thank you for being here. The other attorneys may have some questions for you.
Okay.
Mr. Williams, Mr. Lewis.
Sure.
We had a chance to speak at a prior hearing. If I asked you any question that you don't understand, you just let me know and I'll try to rephrase it, okay?
Okay.
Okay, as I listened carefully to your testimony, I understood you to say the chronology of events was you heard the screeching tires, you heard the collision, then you heard the shot. Do I have that right?
Yes, there was time in between that, but yes.
Right. It may not have been in rapid succession, but what first drew your attention to there being any sort of drama or problem was the screeching tires. Is that right?
Yes.
Then you heard the collision. Is that right?
Yes.
Then at some point in time, you heard a shot. Is that right?
Yes.
The shot occurs after the collision. Do you recall seeing the people struggling before you heard the shot?
Yes.
I got it. So it's screeching cars, you heard collision, struggle, then a shot. Is that right?
Yes.
And from your prior testimony at the prior hearing, you estimated your distance to be about 40 or 50 yards from the actual collision of the two cars. Is that right?
Yes, but I'm apparently not very good at estimating distance because you can see it's not that far on the video.
Okay, but at your prior hearing, your testimony was it felt like it was about 40 or 50 yards. Is that right?
Yes, that's what I said then.
You heard someone else say that they saw a gun. Is that right?
Correct.
And you heard the gunshot. Is that right?
Yes.
Did you ever see the gun?
No.
Did you ever see who ultimately fired the weapon?
I did not.
Okay. Did you describe any of the potential perpetrators to the police when they arrived?
No.
Did you ever give the police any tag to the vehicle that you saw leave the scene?
No.
Okay. Thank you very much, Ms. Page. I'm going to turn it over.
Mr. Clegg?
Tom Fleck, you had testified at a previous hearing, I recall, is that correct?
Correct.
And you had stopped at the QuikTrip to get some gas, right?
Yes,
You had a rental vehicle, did you not?
I did.
My eyesight is not as good as it used to be, but looking at the video, it appears that the vehicle you got out of would have been an SUV, is that correct?
Yes.
Do you recall the make of the SUV?
I do not.
How tall are you?
I'm about 5'7", 5'8".
And how tall was the vehicle of the SUV?
I really couldn't say. I really couldn't say.
When you first pulled up to the gas pump, the gas cap on
Yes.
the SUV you were driving would have been on the passenger side of the
Correct.
And you can see in the video you getting out of the vehicle, correct?
Yes.
You get out on the driver's side, correct?
Yes.
Is there anyone else in the vehicle with you at that time?
No.
Nothing out of the ordinary is happening when you get out of the car, correct?
No.
You go around to the passenger side of the vehicle, correct?
Correct.
You were paying for the gas at the pump, is that a fair statement?
Yes.
At some point, when you first pull in to get out of the car, you notice the Dodge Charger sitting over near the
I do not.
gas pump.
No.
There's no reason for you to pay attention to it at all, correct?
Correct.
You don't know whether that vehicle is occupied or not at that time, correct?
That's correct.
You don't know of your own knowledge whether the motor of that vehicle is running or not, correct?
Correct.
You actually come back into view at some point and go around to the driver's side again. And I think I missed it. Why is it you went back to the driver's side?
I'm not sure. Mr. Williams did ask me why I moved the car, and right. I can only assume it's because it wasn't my car and I wasn't close enough to get the pump into the, so I think I had to adjust.
My mistake. You already answered that question, so I apologize. So and then you go back to the passenger side of the vehicle, correct?
Yes.
And whatever you observed or heard what had happened when you were on the passenger side of the vehicle, correct?
Yes.
Could you see over the top of the SUV?
I think I was at the part of the pump where I was getting the receipt, so I think it was the front of the car that I was seeing over, but probably could not see over the middle part of the SUV.
And you will concede that at least once you go to the passenger side of the vehicle to put the gas in, it is difficult to see, correct?
Yes.
From the video, we can see you on the driver's side of the car. We cannot see you on the passenger side of the car, correct?
Correct.
At some point, is it a collision that you hear first?
Yes, there's some sort of noise from that area, yeah, like a collision that gets my attention.
You immediately direct your attention to the vehicle?
Yes.
Okay. And so, at that point, how long do you watch what transpires?
It's hard to say, but maybe 30 seconds to a minute.
And do you see anyone get into the driver's side of the vehicle that has been backing up?
No.
Do you see anyone get into the passenger side of the vehicle that has been backing up?
No.
But you do see signs of a struggle inside the vehicle, correct?
And around the vehicle, yes. And around the vehicle, like there was somebody outside that was part of the struggle, so it wasn't just inside the car.
My specific question at this time is, do you see a struggle take place inside the vehicle?
No.
Do you ever see two people inside the vehicle?
No.
Do you know the vehicle? When I say the vehicle, I'm talking about the Dodge Charger. When you direct your attention to the Charger, do you recall the driver's side door is open?
I think it is open.
How about the passenger side door? Do you recall that?
I don't recall, but I don't think it was open.
Now, you heard a shot, correct?
Yes.
You heard one shot.
Yes.
Was that shot from inside the vehicle or was it from outside of the vehicle?
I'm not sure I could say. I assumed it was from outside the vehicle.
What was the basis of your assumption?
Because it was very loud.
Okay. And you did not see anyone with a gun, correct?
Correct.
Did you see at the time, you had heard someone say, he's got a gun, or words to that effect, correct?
Yes.
And at that point, you ducked down, correct?
Correct.
You were concerned about your own well-being and safety as well you should be, correct?
Correct.
So at that point, you did not actually see what transpired, correct?
That's correct.
You did not see one individual shoot the other, correct?
Correct.
You cannot offer any sort of opinion to these ladies and gentlemen of the jury as to the distance between the two people when the shot was fired, correct?
Correct.
When you saw them, did you see the two people outside of the car?
So I did at some point see. Okay.
prior to hearing he's got a gun,
Okay.
did you see the two people outside the car?
I saw one man pull the other guy out of the car, so they were both outside of the car.
And were they both standing at that time?
Yes.
Was one noticeably taller than the other?
I don't think I could say.
You said you're 5'7", 5'8" or so. I think I'm 5'8" on a good day. Did you notice anyone who appeared to be 6'9" or 6'5"?
No.
And again, you saw no one with a gun, correct?
Correct.
Did you see any other individuals involved in the situation other than the two people you saw?
I think there was a third person around the car.
Did you see that person with a gun?
No.
Again, you were crouched down. How far?
After this, yes.
How far down the driving are you?
I mean, I'm down by the wheel well. Yes.
You're not wanting to see anything. You're concerned about your safety, right?
Yes.
Did you see that there was a car that backed in? We've seen on the video a car that backed in next to the Charger, correct?
Yes, I saw that on the video.
Did you actually, of your own knowledge, see anyone get out of that car?
No.
Did you see the driver of that car?
No.
Is it fair to say that based on your observation, first off, you weren't focused on that car, were you?
No.
You were focused on the two people struggling, correct?
Yes.
And then once you heard someone say he's got a gun, you were not focused on anything other than your own safety, right?
Yes.
Do you know who said he's got a gun?
I do not.
You know the direction from which that voice came, saying he's got a gun?
If I had to say, it was from the right and behind me. But I don't know precisely. I don't know who said it or precisely where they were.
Okay. You never had a chance to confer with that person, right?
No. We were told not to talk to one another afterwards.
So, but going back to the driver of the car that the individual apparently got out of, that we saw back into the spot, you cannot offer an opinion as to the gender of that person, can you?
No.
You cannot offer an opinion as to the race of that individual, can you?
No.
You cannot offer any sort of opinion as to individual characteristics of that person, can you?
No.
You don't have any idea as to the age of that individual, do you?
No.
There was another car, obviously a Charger, backed into another car, right?
Yes.
That occurred before the tussle, correct?
Yes.
That occurred before hearing someone say he's got a gun, correct?
Yes.
That occurred before the shot, correct?
Yes.
That car wouldn't have been between you and the individuals who were near the Charger, right?
I actually don't remember seeing that car when I saw the struggle. I was pretty locked in on what was going on right there.
Okay, so you directed your attention when you first heard the collision, correct?
Mm-hmm. Yes.
Thank you. Thank you.
The court reporter has to take everything.
Yes.
And even though you directed your attention to the collision, you do not recall seeing the two cars that were involved in the collision, did you?
What I mainly recall is the struggle around the car.
Okay, but I mean, you did not see the other car involved in the collision, fair enough? Or you don't recall?
I did eventually because that car pulled around near my car.
Okay. But that would have, to some extent, blocked your ability to observe the two individuals in the tussle, correct?
Well, I felt like I saw that pretty clearly.
Now my question, did that other car to some extent block your view of the individuals involved in the
I don't remember seeing that car.
Okay. Describe what you saw when you saw the struggle.
So literally I just saw the man outside the car pull the man that was in the car out. And then they were struggling outside the car.
Okay. This was again prior to any shot, right?
Correct.
When they were struggling, how far were they from one another?
Right next to each other.
I'm going to walk towards you. try to duplicate that. We'll come down off the witness stand, just stand right there.
Okay.
I'm going to walk toward you in order to duplicate the distance between those two folks when it's on the struggle. Show me. Right here. Right here. Face to face. Face to face. Good, thank you. Can you have a seat back up on the witness stand? Did you hear either one of them say anything?
No.
At that time, did you see either one of them with a gun?
No.
You never actually saw a gun, correct?
Correct.
When you saw the two individuals face to face, the distance you have just demonstrated here in this courtroom, you had not heard anyone say at that juncture, he's got a gun, right?
Correct.
And once you heard that, you have no idea how far they were from one another because you don't have, right?
That's correct.
You didn't get a tag number of the car that left the scene, did you?
I did not.
You didn't offer a description of the car to the police when they arrived at the scene, did you? The car that left the scene.
Right. I think they asked me about that, and all I could say is that it was a dark colored car.
So what was the last sentence?
All I could say, they asked me about that, the police. All I could say was that it was that I thought it was a dark color.
I mean, I know you didn't get a tag number, but did you even get a glimpse of the license plate?
No.
Okay. And can you say how many people would have been in that car?
No.
Okay. Other than the car that intervened, the car that was involved in the collision that you don't recall seeing, was there were three people, there were two people involved in the struggle, right?
Correct.
There was a third person close to the struggle, correct?
Yes.
Did you see anybody else closer to the two people who were struggling and a third person other than yourself?
No.
Fair enough, ma'am. I appreciate you coming. Thank you very much.
Thank you. Ms. Drake, do you have any questions for Ms. Smith?
I just have a couple of questions.
Okay.
Now, in the video we just saw, other than you getting in and out of your car and walking around, there is no video of you physically at the pump that we've seen thus far. Would that be a fair statement?
Yes.
And the make and model of the second car that was involved in the collision, wreck, whatever you want to call it, with the Charger, do you know the make and model of that?
Not for sure, no.
Okay. And would it also be safe to say that you don't know the make and model of the vehicle that you saw leave?
Correct.
And I believe you said whenever you heard the he's got a gun, you thought it was behind you to the right?
Yes.
And whenever you saw the two individuals that were struggling face to face, they were approximately the same height?
Approximately, yes.
That's all I have. Thank you.
Mr. Williams, any reader?
No, Your Honor.
All right, wait, does the state want to release Ms. Smith?
Yes, sir.
All right, defense? Okay, Ms. Smith, thank you for being here. You are released. You can stay in the courtroom or go wherever you need to go. Thank you very much. Ladies and gentlemen, at this time, we're going to take our lunch. Eddie, I understand the jury dining room is still open, so we're good to go today. We're going to start court back at 1, so just stay with your bailiffs. Leave your notepads in your chair or on the bar is fine. Any issues from the state before we adjourn for lunch? Any issues from the defense before we adjourn for lunch? Okay, we'll see you back at 1.
Yes, ma'am.
Armando, thank you very much for this. If I could get one of these on each trial, it would be so helpful. Just thank you. It's very helpful to me. And whoever made this, Mr. Melvin or Mr. Williams, this is very helpful too. I have my own that I have made. Huh? Yeah, but I mean, this is extremely helpful to me because I do keep track. I don't know if all judges do, but I keep track of every piece of evidence. All right, state's ready?
Yes, ma'am.
And defense is ready for the jury?
Yes.
Okay, come on in. Thank you. I hope y'all enjoyed your lunch. I know we had you back at 1, but this time it's my fault. I was back here at 1, but I had a legal issue that I needed to talk to the attorneys about, and it took me a few minutes to do that. So I'm sorry we didn't get you right back in here at 1. It's on me. I think we were with the state's case. State, call its next witness, please.
Mr. Owen Waits.
Okay. Sorry, what did you say?
Owen Waits.
Okay. Good afternoon. I'm sorry. When you don't have windows sometimes, you know. If you'll remain standing for just a moment and raise your right hand. Do you swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. If you'll please be seated, Mr. Waits, correct? Okay.
Mr. Waits, thank you for being here. Where do you live?
I live in Gwinnett County.
And do you remember July 10th, 2022?
I do.
What happened on that day?
There was a shooting at the QT and Peachtree Corners.
Now, where were you? How far away were you from that shooting?
Probably 200 yards. I was across the street at the Lidl parking lot.
And can you describe what you saw?
Sure. So as I witnessed the scene, I was across the street, across Peachtree Parkway. I saw what drew my attention, the verbal altercation that I heard between the defendants and Mr. Coleman. I saw a scuffle of two individuals outside Mr. Coleman's car. I saw a shooting take place and Mr. Coleman fall in the parking lot. And then I saw the black vehicle depart the QT parking lot and move south on Peachtree Parkway.
Do you know what the make of vehicle was that departed?
It was a Mercedes.
Now, if you had said Cadillac, would you be mistaken?
I would, yeah. You know, I was at a distance at the time, and I know on my call to 911, I reported as a Cadillac. It was a sedan that was black from a distance that looks pretty similar, but I think other evidence would show that it was definitely a Mercedes.
Your Honor, I'm going to object at least on testifying on his personal knowledge and stuff that was read about the case.
Okay, Mr. Williams, legal response to Ms. Drake's objection.
I will rephrase the question.
Okay, wait a minute. I'm going to sustain the objection, and I'm going to...
I would ask to strike his response.
Okay, I'm going to strike Mr. Waite's response.
Mr. Waite, what helps you determine it was a Mercedes or another vehicle?
So my initial observation, I saw the vehicle as a black sedan that looked a make or model of a Mercedes or a Cadillac.
Did you do anything with your phone, take a picture or anything?
Yes, I took a picture of the scene.
Did that help you in any way?
Yeah, it froze the scene in time for me where I could see both vehicles involved.
Your Honor, my approach with what's marked for ID as State's Exhibit 4.
It's previously marked as the State's Exhibit 4. You want to approach the witness? Is that... Yes, certainly. Feel free to move around the courtroom however you need.
I'm showing you the State's Exhibit 4.
Mm-hmm.
You know, can you tell us what that is if you recognize that?
Yes, that's the picture I took on my cell phone.
And is that of the QT you're describing to us today?
Correct, from my point of view, and you can see the defendant's vehicle in the center there by the tree and Mr. Coleman's vehicle.
Your Honor, I'm going to object to referring to that as the defendant's vehicle. He did not identify anybody. There's going to say it's the defendant's vehicle. He's been told that by somebody.
All right. Legal response, Mr. Williams, to that objection.
He was instructed.
Okay. I'm going to strike Mr. Waite's testimony. I'm instructing this jury not to consider either one of the statements I have struck of his testimony. You cannot consider those in your deliberation. Either the later evidence would prove it's a Mercedes, nor the defendant's vehicle. That has been struck, and you cannot consider it in any deliberation against any of these defendants. So both of those statements have been struck from the record.
Your Honor, I tender States 4 into evidence.
Do you have an objection?
Yes,
That's sustained.
Mr. Waits, State's Exhibit 4, can you tell us what that is?
Yes, this is a photograph I took on July 10th, 2022 on my cell phone.
And the incident you're here talking about, was it around the time when you took that photo?
Yes.
Has it been altered or tampered with in any way from when you took the photo?
No.
truthfully and accurately represent what you saw on that?
Yes, sir.
Your Honor, I intend to state Exhibit 4 into evidence.
State's Exhibit 4 is admitted without objection.
Your Honor, I publish 4.
Certainly, Mr. Williams.
So, Mr. Waits, and there's a larger screen to your left. So you're
And
not...
there's a monitor. Mr. Waits, there's a monitor right here that if you can see it better, whichever's more comfortable.
So you're not even in the QT itself, is that correct?
That is correct, sir.
But did it... What drew your attention to what was going on over there?
The verbal altercation in the parking lot that I heard, people shouting at each other, right under that tree, as you can see in the middle of the photo there. Pretty uncommon for Peachtree Corners. You don't hear people shouting at each other very often. So I was just loading groceries in my car, and I heard the shouts initially was what drew my attention.
And the vehicle that you've described that went away, can you get up and point to that vehicle?
Sure. Yeah, it's this black vehicle right here.
Thank you. And did you call 911?
I did, yes.
And if you listened to that 911 call?
I have, yes.
Your Honor, at this time, State publish what's already in evidence as State's Exhibit 5. It's a 3-minute 911.
Okay. Hold on just a moment. Do you want an audio charge? I know there was Mr. Lewis. Okay. Okay, before you play that. Ladies and gentlemen of the jury, you're about to listen to an audio. There may be parts of the audio that I have directed to remove for presentation, as they are not to unnecessarily extend the duration of this trial. Removed portions may include periods of dead time or matters bearing no relations to the case before you, or for specific legal reasons that are not proper for your consideration. You're not to draw any inference or for or against either party based on the removal of portions of this audio, if there are any, by this court. As you listen to the audio, you may hear officers, 911 operators who work for law enforcement make certain statements to this witness. I caution you that the declarations or statements of any law enforcement or anyone on this call are not evidence, and you should not consider such statements as evidence unless such statements are proven to you by other competent evidence. All right, go ahead, Mr. Williams.
Gwinnett County 911, what's the location of your emergency?
The QuikTrip on Peachtree Industrial. Did you already get the call about the shooting?
What is the address?
I don't know the exact address.
Okay, I'm asking because there are many QuikTrips in that area, and you're saying Peachtree Industrial. We weren't told Peachtree Industrial.
Okay.
Is it
right
Peachtree Parkway near the Forum?
Yeah, exactly, that one.
Okay.
Right across from Illegal.
Did you witness it?
I did, yeah.
Okay, and where's the person that shot at someone?
They took off in a black car and went south on Peachtree Industrial.
Do you know what kind of car?
It was a black Cadillac, but I was too far away. I'm across the street, but I saw it was like a black Cadillac sedan.
Okay, and they went southbound on Peachtree Parkway?
Correct.
Okay, and did you see the person that did it, what they looked like?
It was a black male. That was the only thing I could tell from it.
About how old? Do you know?
Early 20s probably. Not very old.
Okay, and you didn't get a tag?
No, I was too far away. I tried.
Okay,
and just one shot fired, and it looks like he hit the guy who's laying on the ground right there.
Your name?
My name's Owen.
Owen, what's your last name?
Waits, W-A-I-T-S.
Okay, and your phone number, Owen?
513-490-0002.
Okay, we've got officers and paramedics on their way. They're going to be out there soon, okay?
Yep.
Did you see anything? We have your contact information. Did you see anything happen before the shooting? Like, could you hear arguing?
Yeah, there was. So what got my attention was voices. I'm probably 200 yards away across the street, and I heard shouting across the street at the gas station, which is abnormal. And there was two individuals, the one that was in the car now that's laying on the ground, and then another black car, the one that drove away, had pulled up. They were shouting back and forth. Like, I think they were trying to steal this person's car or something. And the guy pulled up in the one black car, and then he ran over to the driver's side door of the car that's parked in the gas station. They argued. He opened the door. The guy got out of the car, and then that's when he shot him. And then the guy that had pulled up jumped into the black car and drove away.
Okay,
I don't know if there's more than one individual in the black car that drove away or not. I didn't see if he actually got in the driver's seat or the passenger seat, but...
Okay. Well, we are on our way. We'll be out there soon, okay? And they may call you to get if they have additional questions. So just be sure to answer your phone if it should ring, okay?
Yeah, we'll do. I'll hear the sirens now.
Thank you. Bye-bye.
And the ambulance is there. Thanks.
Mr. Waits, is that the call that you made?
Yes, sir.
Thank you so much. The other attorneys may have some questions for you. Sure.
Lewis?
Prior hearing, is that fair to say?
Yes.
Fantastic. I don't know if you recall that, but if I ask you a question you don't understand, you just let me know, and I'll try to rephrase it so that we're all on the same page. Okay?
Yes, sir.
If I understood your testimony, it was the verbal altercation that first drew your attention towards the parking lot at QT. Is that fair to say?
Yes, sir.
And at the time when you looked towards the QT, you were in the parking lot of a store across the street. Is that right?
Yes, sir.
I got you. You hear some arguing, then you hear a shot, then you see the person that shot jump into a vehicle. Is that right?
Yes, sir.
Okay. You snap a picture, and I'm assuming you snapped the picture before you call 911. Is that fair to say?
Yes.
Okay. In terms of estimating the time, and a range is fine. The time between the time you snap the picture and you call 911, is that less than a minute?
Yes.
Okay, good. On the 911 call, you called the vehicle a Cadillac. Is that right?
Yes.
As best you can tell, that's what you thought it was. Is that right?
Yes, sir.
Now, when you're on the phone with the 911 operator, and you're telling her that you think it's a Cadillac, is that because of what you remember as the car's exiting, or is that because of what you were examining in your phone?
I would say both. Both from my visual recollection and the photo.
Fantastic. Now, I'm assuming that after you took the photo, you would try to expand or enlarge the photo to be able to try to tell what type of car is in the photo. Is that fair to say?
Yes.
Okay. Did you do that before you were on the 911 call, as you were on the 911 call, or afterwards?
Right before.
Okay. Give the 911 operator the best description that you can, and what is the time in between the time you call 911 and the police arrive?
Approximately 3 minutes.
3 minutes. In that 3 minutes, are you continuing to try to manipulate the photo that you've taken of the vehicle to try to see if you can determine anything additional from the photo?
After I hung up with 911, yes.
Fair enough. Are you trying to see if there's any tag that you can see in the vehicle or get a better description of the vehicle?
Correct, yes.
From your vantage point, when you took the photo, were you able to see how many individuals were in the vehicle?
No.
I got you. So there's about 3 minutes, and you're trying to manipulate the photo to try to give a better description. Are you making your way towards the QT at the same time that you're doing that?
Not at the same time. It was a few minutes afterwards. So after the police and the ambulance arrived, I drove over to the QT.
Okay,
Speak with
good.
the officers.
Is it only after the police and ambulance arrived that you then cross the street in your vehicle?
Correct.
All right. At that point in time, you get some officer's attention to indicate that you've got some information. Is that fair to say?
Yes, sir.
At the point where you make the statement to the police, are you able to tell a make and model at that time?
No.
Okay.
No, not immediately, no.
So as you're talking to the police officer, do you still have sort of Cadillac in your mind?
Yes.
Okay, and even though you're manipulating the photo, try to get a better look. As best you can tell, when you first talked to the police officers that arrived, it was a Cadillac. Is that right?
Yes, sir.
You wrote a statement ultimately to, you wrote a statement actually made a statement to the police. Is that right? You wrote a written statement?
Yes, sir.
Take a look at D1.
Sure.
Is that the statement that you made?
Yes, sir.
It's a photocopy of the statement that you made. Is that right?
Correct.
That's in your handwriting?
Yes.
Okay, good. And this photo, this written statement was written how long after you spoke to the officer, the first officer that you spoke to?
Within the hour, I would say.
Within the hour.
Yeah, it says 12:58 p.m. So.
What time did you first recall calling 911? Do you recall that?
I don't know exactly what time. It'll be on the tape.
Okay, it would somewhere between a half an hour to an hour after you called 911, you wrote the statement. Is that fair to say?
That's fair.
Fantastic. In the statement, you described the vehicle that's pulling out of the QT as a black sedan. Is that fair to say?
Yes, sir.
You didn't call it a Cadillac, and you didn't call it a Mercedes. Is that fair to say?
Yes, sir.
Okay. This morning, you indicated that the vehicle may have been a Mercedes. Is that right?
Correct.
Okay. Is that from information that you received from a press release?
Publicly available information, yes.
I got you. And that's the same way when you testified to the jury when you called Mr. Coleman's name.
Correct.
That you didn't know Mr. Coleman at the time. Is that fair to say?
That's fair.
No relationship to him. Is that fair to say?
Yes, sir.
You as a result of speaking to the police or later press releases, you learned that the person who was shot, that his name was Mr. Coleman. Is that right?
Yes, sir.
I got you. I believe that your testimony was that you only took one photo. Is that fair to say?
Yes.
All right. Those are all the questions that I have. Thank you very much. Thank you.
All right, Mr. Clegg, do you have any questions for Mr. Waits?
Wait, my name is Tom Clegg. I just have a few questions. If you need me to repeat a question, please feel free to ask me. I have hearing aids in, so lean into the microphone and don't be afraid to project a little bit, okay?
Yes, sir.
Accommodate me, okay. If I'm understanding correct, how long had you been out? Were you in the process of putting your groceries in your car when you heard the initial verbal altercation?
5 minutes. How long was I in the parking lot?
Yeah.
Probably less than 5 minutes.
Were you in the process of still putting the groceries in the car?
Yes.
So you were outside of your car?
Correct. At the tailgate,
You
yes.
had not gotten into your car to drive away? Correct?
No, sir.
And the first thing that directed your attention across the street was the verbal altercation, correct?
Yes, sir.
When you looked across the street, you were able to see two individuals, correct?
Yes, sir.
Both of those individuals were outside of their car, right?
Yes.
Both of those individuals were standing up, correct?
Yes.
And both of those individuals were in close proximity to one another, correct?
Yes.
Can you estimate, for the benefit of these fine folks here on the jury, how far the two individuals who were engaging in the verbal altercation would have been from one another?
2 feet or less.
2 feet or less? Could you tell from your vantage point whether both of them were arguing?
Yes, they're arguing with each other.
And both of them were raising their voice, is that correct?
Yes.
And if you could speak up just a bit.
Sure.
Were you able to hear anything, specifically anything they had to say?
Nothing specifically, no.
When you first directed your attention to the individuals, did you see either one of them in possession of any sort of firearm?
No.
How long did the argument go on for before it escalated?
Less than a minute. Less than 1 minute.
Now, there had been apparently, well, let me ask this, did you hear anything that would have been consistent with one vehicle striking another vehicle in the parking lot?
No.
Did you see one vehicle strike another vehicle in the parking lot?
No.
Did you ever hear anyone from across the street yell out, "He's got a gun"?
No.
You never heard anything of that sort whatsoever?
No, sir.
In the parking lot, you can, from your vantage point, you can see, I guess if you're standing on Peachtree Parkway, you're looking at the QT, the incident would have happened on the left side of the parking lot, correct?
Yes, as you look at the QT.
In the left side of that parking lot, do you see any other people other than the two people engaging in the argument?
Exhibit 4 shows you what I saw. There are other vehicles in the photos, so. But of the 2 individuals, those are the only 2 people I saw.
People outside of their car, you did not see anyone else, correct?
Correct.
Did you see a woman looking over an SUV?
No.
Did you see a woman crouching down behind an SUV?
No.
Did you see a second individual approach the 2 people who were arguing with one another?
No.
Did you see anyone actually get out of the black sedan as you described it in your original statement to the police, correct?
Yes.
You actually did see someone get out?
No, I'm saying I'm confirming the black sedan, yes. But no, I did not see someone get out. He was already out of the vehicle when my attention was drawn.
Yes or no? Did you see somebody get out of the black sedan?
No. No.
Did you see a gun produced at some point during the course of the argument?
Yes.
And which individual produced the gun? The shooter, obviously, right?
Yes. The shooter on the left side from my point of view.
How far would the shooter have been from the individual who was shot at the time that the gun was produced?
Less than 3 feet.
Less than 2 feet?
Less than 3 feet, probably.
And at that point again, you heard nothing whatsoever about he's got a gun, right?
Correct.
And then you heard the shot, right?
Correct.
The victim went down almost instantaneously, correct?
Yes, sir.
This was well away from the Dodge Charger at the scene, right?
Right next to it.
Was the doors of the Dodge Charger open or not, as you recall?
The driver's door was open.
Did you know that at the time when this happened, or did you know it after you drove across the street to observe?
I could see it at the time.
All right. You obviously did not see the tag of the car, right?
No, sir.
Certainly had no idea whether it was a Georgia plate or a plate from another state, right?
No, sir.
If you can, and I don't know if you can or not, but did you see did you see a BMW?
I don't recall one.
You do not recall seeing a black BMW come into contact with the Dodge Charger, right?
No.
There was let me ask you this, were you able to see the driver of the black sedan which left the scene?
No.
Is it fair to say that you are not able to offer any sort of opinion as to how many people were in the car, the black sedan, when it left the scene?
That's fair.
You did see one person get into the black sedan after the shooting, correct?
Yes.
Where did that person get into the black sedan?
On the passenger side in the front.
The front passenger side?
Yes.
And that's the person who would have done the shooting, correct?
I believe so, yes.
You did not see any other individual. It must have been him, logically, correct?
Logic would say that, yes.
Did you see him with the gun when he got into the car?
No.
So you know that at least one of the people in the black sedan was a black male, correct?
Yes, sir.
Again, you don't know how many people altogether were in the black sedan, correct?
No.
You don't know the ethnicity or race of the driver of the sedan, correct?
Correct.
You don't know the sex of the driver, correct?
No, sir.
You don't know the approximate age of the driver, correct?
No, sir.
You cannot offer any evidence whatsoever concerning individual characteristics of the driver, correct?
Correct.
Fair enough, sir. If I'm understanding correctly, and let me know if I'm not, whatever you saw occurred outside of the vehicle, the Dodge Charger, I guess it is, right?
That's your words? Yes, outside the vehicle.
You never saw either one of the two people who were engaged in the altercation inside the vehicle, correct?
Correct.
You never saw one individual either following another out of the Charger or being pulled out of the Charger, correct?
Correct.
You did make the 911 call, right?
Yes, sir.
In the 911 call, I think it's been established, you referred to the black sedan as a Cadillac, correct?
Yes, sir.
Now, you didn't say possibly a Cadillac, correct?
I don't believe so.
You specifically said Cadillac, correct?
Correct.
And you used the word Cadillac 2 different times, correct?
Yes.
This would have been before you would have actually written your written statement that I think you have in front of you, defense exhibit number 1, correct?
Yes, sir.
Defense exhibit number 1 was prepared by you at 12:58 in the afternoon, correct?
Correct.
That would have been approximately 18 to 20 minutes after the shooting, correct?
Yes.
The police were on the scene relatively quickly, right?
Yes.
You had already made the 911 call, correct?
Yes.
The events were fresh in your mind, correct?
Yes.
You went from initially describing the vehicle as being a Cadillac to simply describing it as a black sedan. Was there a reason why you did not identify the specific make of the vehicle at the time that you made your written statement?
Yeah, I had a doubt as to what the exact vehicle type was.
Honestly, you simply did not know, correct?
Correct.
And even though you had had a chance to observe the photograph of the vehicle prior to making that written statement, correct?
Correct.
So if I'm understanding correctly, when you wrote that statement describing the vehicle as a sedan, you had, 1, observed the shooting, correct?
Yes.
2, seen the black sedan leave the location,
Yes.
correct?
Yes.
3, taken a picture of the black sedan, correct?
Yes.
4, in an opportunity to actually look at the photograph of the black sedan, correct?
Yes, sir.
Even after having done all of that, you were not comfortable writing on your written statement what kind of car it was, correct?
Correct.
Let me take a look and see my notes. Let me ask you this. The individual who got shot, prior to the shot being fired, did you ever see him on the ground?
No.
Were you able to offer any sort of opinion as to the relative height of the two individuals who were engaged in the verbal altercation?
I mean, no. I mean, roughly the same height, if you want to give me a
How tall are you, sir?
5'9".
5'9". Can you offer, and I understand you were about 250 yards away? 200, 250?
200, yeah, roughly.
Photograph pretty much shows the distance between you and the scene, correct?
Correct.
So And if you can't do that, that's fine, but can you offer these folks on the jury any sort of opinion as to the height of either person engaged in the altercation compared to you? Were they shorter, taller, similar?
I don't want to offer speculation. I would say they're roughly my height.
And did they appear, the two individuals who were in the altercation, appear to be approximately the same height?
Approximately, yeah.
Fair enough, sir. Okay. Just to make sure, there was one shot and one shot alone, right?
That's what I heard, yes.
And you never saw a second person approach with or without a handgun, right?
I did not.
Thank you very much, Mr. Waits. Appreciate you coming.
Thanks, sir.
Drake?
Hi, sir. How are you?
I'm good, ma'am. How are you?
I'm good. I'm just going to try to minimize my questions a little bit. I just want to clarify, and I know you've already said this, but I just want to make sure that I heard. You did not see anybody get out of the car when you looked. Both individuals were already out of the car.
Yes, ma'am.
And what originally drew your attention was that you heard loud voices.
Yes.
And isn't it true you also saw them physically struggling?
Yes.
And prior to the individual being shot, did you see either of them with a gun?
No.
Did you see where the gun came from?
The shooter produced it from somewhere in their general body area.
Did they produce it from their pants, from their back, or do you recall?
I don't recall exactly where.
And was that immediately prior to the shooting?
In my view, yes.
And how long do you think that the struggle went on between these two individuals?
Maybe 20 seconds. It was pretty quick.
Okay, it was 20 seconds?
Maybe, yeah, less than that. No more than 20 is what I would say.
If I can have just a moment, please, Your Honor.
Certainly.
So you said 20 seconds?
Of confrontation?
Yes.
Yes.
And that was before the gun was drawn?
Correct.
Do you remember testifying at another hearing back in October of 2023?
I was here, yes. I don't know if we can reference that or not.
Okay, but do you remember testifying in a hearing back in October of 2023?
I do.
Were you sworn in at that time?
I was.
Your Honor, may I approach, please?
Certainly.
I'm sorry, page 158 and 159.
What line? Starting at what line?
Lines 24 through line 1 on 159. Now, you said 20 seconds. Back in October of 2023, you said it was a minute to 2 minutes, correct?
That's what the record shows.
Okay. Did you say that?
I'm sure I did, yes.
In October of 2023 is certainly closer in time to 2022 than October of in January of 2025. Would that be fair to say?
Yes.
And the individual that pulled the gun was on your left.
Correct.
You stated?
Yes.
And I understand the individuals are roughly the same height. Would you describe them as average height?
Yes.
And would you describe yourself as average height?
Yes.
And you're approximately how tall?
5'9".
I believe that's all I have. Thank you, sir.
Thank you. Mr. Williams? Review.
Mr. Waits, referring to the defense one, your written statement, you wrote that it was a black sedan that you saw, correct?
Yes, sir.
And did you just testify that that's because you had some doubts as to what the brand, model, make was?
Correct.
But you did state in that written statement it was a Challenger, the other vehicle. Is that correct?
It is written there, yes.
Were you more certain about that make and model?
Honestly, the Challenger and the Charger to me are pretty interchangeable vehicle models, so I might have seen it as a Challenger, but it could be a Charger.
It's safe to say it was a pretty emotional experience for you at the time?
Certainly, yes.
Your Honor, I'd like to publish State's 5 authority and evidence to show to Mr. Waits.
You're going to play. Okay, that's not Exhibit 5.
Exhibit 3.
You're going to publish Exhibit 3? Certainly. Okay. Well, hold on a second.
This may be premature, but if he is showing this to the witness in front of the jury to maybe refresh his recollection, I would object to that. If he's going to ask specific questions, then obviously I have no objection. But if it's to show him to refresh his recollection, I don't necessarily know that that's proper to do in front of the jury.
Absolutely. Okay, this is one of those times that I need to have a discussion about a piece of evidence and whether it is played, and so I'm going to ask you to go back to the jury room for a moment, or a few moments. Assuming we want Mr. Waits to step off the stand and be outside? Yes, okay. Mr. Waits, and if you'll not talk, you can't speak to anybody, just if you'll just wait right outside, we'll be back, have you back in just a few minutes. Okay, I know I've heard from Ms. Drake, go ahead.
Your Honor, I just want to elaborate a little bit further. I wanted to object when we got too far, because if we got too far, then we have all sorts of issues. I mean, obviously, he, in his statement, wrote about it being a Challenger, and he said that they're interchangeable. Obviously, my question is going to be, on recross, you wrote that statement while on the premises the vehicle was still there. So I guess I'm not certain if he is trying to show the video to refresh the witness's recollection or to show the witness something that the witness does not independently recall, which I think would be improper. If he's asking for specific locations and stuff, obviously I'm not going to have an objection, but I wanted to stop a train that the board got over.
All right, Mr. Lewis, you had something?
I'm not quite sure what goal is, but we've already dealt with this witness. This witness is very comfortable testifying about after the fact information in a very fluid way. Mr. Coleman, the Mercedes, and these are all things that we've done after the fact. So I don't have a problem. I don't know why the prosecutor doesn't show the video, but I know that the witness, this particular witness, is comfortable incorporating post information as if it was known at the time. I know that he went to PT. I'm less concerned about what he called the car because I think he was on the ground. Based on the testimony that we heard, he likes to stay somewhere around PT grounds, and we know that the vehicle was there for an extended period of time. if it was as to where people were, I'm going to object because I think that it's easy to plan to see in this particular person's case.
Mr. Clegg, anything? But you do care as to which portion is played.
Yeah.
That's the only, you're,
They're outside of the car, basically, which says, we're outside of the car, they're outside of the car, right, you're the argument, that's like red flag. That's what he can testify to, and he can see that portion of the thing. Anything that is transpired beforehand, no, I don't like to show it to you.
okay. Mr. Williams?
This is not to refresh recollection, it's to ask specific questions of Mr. Blades. Has not seen this video, but the video is in evidence already. So I would ask,
Okay,
you could ask
what,
specific questions.
you want to play the whole video?
No, Your Honor, just seconds from when the vehicles are side by side until Mr. Coleman's pulled out and the vehicle drives off. That's it.
Okay, would that be from the shouting?
That includes the
Oh, okay, so what's your response to Mr. Clegg's point, which is this witness has testified the shouting made him look? Why do you want anything before? What's the legal grounds for showing him something before other than to just show the video again?
Well, redirect because of the vehicles. There will be a question about black sedan and Challenger Charger. We've got the two vehicles there, and if this could be what he's described and testified to.
Isn't that refreshing? You're trying to get him to refresh his recollection with this video to identify? I'm a little confused because we
have black sedan, and if it could be, this could be included within what he wrote as black sedan, on what he was not sure about on the 911 audio as well, whether what we display, which will only be a couple seconds of the video, could be included in what he's written and then described on audio.
Okay, so you're going to ask him, is that the car you saw leave? Or do you now, after seeing this, recall it to Mercedes?
Could this be the vehicles? I'm not going to say
Okay.
if it's a Mercedes or not.
Okay, could this be the vehicle you saw at QT, and could this be the vehicle you saw leaving the QT?
Yes, Your Honor.
Okay. Yep.
Where vehicles are side by side, vehicles rolling out, so from there they would have been when the picture was taken.
Yeah.
That's where I think the issue is. Obviously, the evidence is okay, yes, but only as a human asking questions about, is that the car that you saw when they're right next to each other? I don't know if that's proper.
Okay.
We'll start from that portion. We've got it already queued up. It's on the screen.
Okay, so you wanna start from there.
I'm fine with it, because I think that's where the stopping thing, if it was being young, is obviously the sound, but if it was being young, that's where it would have been. That's where I think the stop.
And then it would be stopped after the Mercedes leaves QT.
Yes, Your Honor.
Okay. Any further argument that portion, just limiting to that portion? Any objection or further argument from the defense?
No, I didn't.
Okay.
I have to say that I'm thinking on how, so I apologize. My thoughts are on the edge of what if we're starting here. What on earth are we going to elicit from the witness? I guess that's not
My understanding is the state wants to ask this witness, could that be the Charger or that you described as Challenger? And that, could that be the car that you described as Cadillac?
But that would be speculation.
Yeah. Yeah. If it's asked that way.
Especially if they show that vehicle leave, of course he's going to say, well, yeah, that's what I thought.
I think my objection, I think the state was seeking to comply with it, and I will defer to the right superior legal acumen and knowledge.
And obviously, this can't say, I think that's what we're saying. Obviously, it's that now on further review.
Okay, I agree with Mr. Lewis on that. So we're going to play it, and the questions are going to be limited to, could this be the car you saw leaving the QT? Is that correct, Mr. Williams? And could this be the car that you wrote down in your statement was a Challenger? Any objection for those two questions going to this witness with this portion of the video?
Your Honor, I don't have an objection at this point. I would just like to reserve the right, depending upon the phrasing of the question and kind of what happened, to still object under this.
Certain. Certain. Okay. Oh, go ahead.
Your Honor, if I may, since the jury is already out, can we take a 30-second break, since this may go through the actual testimony before we bring the jury back in, since they're out?
Okay, you want to take a...
A 30-second comfort break.
Oh, a comfort break. I'm sorry. I didn't know if you needed to...
No.
Okay. 30 seconds?
Let's give me a little bit longer.
I mean, let's be realistic here. Well, you want to go ahead and take a comfort break. They're taking a comfort break. So we'll take if we can do 5-minute comfort break, that'd be great. I don't think 30 seconds is going to get anybody anywhere. Yes. You're killing me.
yet. Watch it.
I just generally point it, yes.
Okay, if we could the DA's office get Mr. Waits? Thank you. Investigator Ray, thank you. Come on up here. Thank you. Yeah, please. Thank you so much. You're still under oath, but state ready?
Yes, sir.
Okay, defense ready?
Yes.
Okay. All right, bring him in. Thanks. Go ahead. Mr. Williams, thank you.
Mr. Waits, I'm going to show you what's already in evidence as State's Exhibit 3. If you can take a look at the screen.
You can see the monitor right there.
Yes, ma'am.
And could these be the vehicles that you were describing?
Yes, sir.
So the black sedan, which one would that be?
The one on the left here is the one when I mentioned black sedan in my statement.
And what about the Challenger?
That's this one behind here.
Could you step down and point on the big screen for the jury?
So, black sedan is what I identified as the challenge in my statement.
And in addition, Mr. Waits, like we said, there was a lot going on. It was an emotional time.
Yes, sir.
And are you maybe not the best identifier of car brats?
I think that's fair.
The other lawyers may have some follow-up. Thank you.
Oh, certainly. If you put the photo back on.
Mr. Waits, it's my understanding, based on your testimony, that after the police arrived, you drove across the street to the QT. Is that fair to say?
Yes, sir.
So it's fair to say at the point in time when you spoke to the police, that vehicle was still parked right there. Is that fair to say?
Yes.
Okay, there had been a sheet covering Mr. Coleman. You later learned his name, I think Mr. Coleman. But the vehicle and Mr. Coleman's body was still there when you were talking to the police. Is that fair to say?
Yes.
I got it. So whether it's a Challenger, Charger, that vehicle never moved. Is that right?
Correct.
That's all that I have. Thank you.
All right. Mr. Clegg? Ms. Drake? Okay, state, may we release Mr. Waits?
Yes, Your Honor.
Okay, and defense? Okay, Mr. Waits, thank you. Okay, that was not tendered. That's Mr. Waits' statement at the scene. Okay. D1 is admitted without objection. Mr. Waits, thank you very much for your testimony. You are released. You can stay in the courtroom or go back to your life. Thank you. All right, State call its next witness.
Thank you, call also, but please stand.
Good afternoon. And raise your right hand. Excuse me. Do you swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth?
I swear.
Thank you very much. Please be seated.
Good afternoon, sir.
Good afternoon, sir.
Could you introduce yourself to the jury?
My name is Officer William Merkley, Merkley.
How are you employed, sir?
Currently with the Gwinnett County Police Department.
How long have you been with the police department?
I've been with Gwinnett County for 6 years.
Do you have prior law enforcement experience?
No, sir.
Post certified.
Yes, sir, I am.
Post as peace officer standard and training.
Yes, sir.
Gives you arrest powers in the state of Gwinnett.
Yes, sir, it does.
What's your current assignment?
I'm currently assigned to Gwinnett County Police Department Special Victims Unit as a detective.
Okay. And I'm going to need you to speak up because I'm hard of hearing and one of the defense counsel.
Yes, sir.
Thank you.
July 10th, 2022, what was your assignment, sir?
I was assigned to our West Precinct as a uniform officer, working calls, responding to calls of service, working accidents, and responding to crime scenes.
Does West Precinct encompass the Peachtree Corners area?
Yes, sir, it does.
Were you in fact called to the QT at the Peachtree Corners Forum?
I was.
And this is just for the record, the QT, Peachtree Centers, that is actually in Gwinnett County, correct?
Yes, sir, it is.
What did you see when you arrived?
We were dispatched to a person shot call at that address. When I arrived, I observed a black Dodge Charger parked next to the air pump outside the QT. There was a black male laying on the ground, face down, in a pool of blood. I was told by fire department on scene that the victim at the time was deceased.
How quickly, from the time that the 911 call went out, did you actually arrive at the scene?
Within 10 minutes.
What were your duties and responsibilities when you got to the scene?
Once at the scene, secure the crime scene, make sure nobody comes in, tampers with anything, moves anything. Once it was determined where the victim was deceased, start canvassing for witnesses. I checked with QT to check for any security footage they had at the scene of the incident.
Were you the first responding officer?
I was not. Officers had gotten there before me.
Just moments before?
A few minutes.
Okay. And did you actually secure the scene, get the QT video, and some of the other things like that?
I did, yes.
And did you stay on the site for a decent amount of time?
Yes, we did.
Were you there when crime scene responded?
Yes, sir, I was.
Did you see and place evidence markers?
I did.
What's the purpose of evidence markers?
It's to note items of importance to be documented, photographed. Usually they're either numbered or lettered to lay out how they found them and where they were on the scene.
I'm going to show you what's been previously marked. Show the defense counsel States Exhibit 6 through 20. If you take a moment to refer to States Exhibit 6 through 20. chance to look through the photographs?
Yes, sir, I have.
And are those photographs true and accurate representation of the scene as you saw it July 10th, 2022?
They are.
Judge, we tender states 6 through 20 at this time.
Any objections?
No objection, sorry, no objection.
States Exhibits 6 through 20 are admitted without objection.
Officer Merkley, permission to publish this?
Certain.
Officer Merkley, I'm going to walk you through states 6 through 20, all right?
Yes, sir.
Let's look at states number 6. Can you give a brief description for the jury and for the record about what state 6 depicts?
This is Mr. Coleman outside his vehicle as he was found when officers arrived on scene.
Okay. And the car to the right of Mr. Coleman, what kind of car is that?
That is a Dodge Charger.
Thank you. Go through state 7. Is that a closer up view, Mr. Coleman?
Yes, sir.
I see some crime scene markers down there. Those were placed by CSI, sir?
Yes, sir, they were.
States 8. Is that a reverse angle of the body that you just mentioned, Mr. Coleman?
Yes, sir.
Now, as you look at state 7 and state 8, do you see any firearm that's on the ground at all?
The firearm, just an empty holster.
You referred to an empty holster, sir. That states 9 that's going to be coming up on the screen. Sorry. Is that the holster, sir?
Yes, sir.
Is there also something else found on the ground by the body of Mr. Coleman? I should refer you to states 10.
Yes, that was found on the ground by Mr. Coleman.
States 11. What's in states 11?
It's a fired shell casing.
Okay, let's talk about bullets and shell cases for just a second. Any of the jury members might not understand the difference. Can you describe what a shell casing is as opposed to a bullet?
So a bullet is an intact cartridge. It has the projectile still in it. It hasn't been fired. When a bullet is fired, what's ejected out of the gun, if it's a semi-automatic handgun or any semi-automatic firearm, that shell casing that houses the primer, the powder, and the bullet itself ejects out of the gun, leaving just the cartridge behind.
So you talked about a semi-automatic handgun. Is there a handgun known as a revolver?
There is.
What's the difference as it handles the casing in a revolver and a semi-automatic?
Revolvers don't eject fired casings unless you do it manually.
So, could you describe how a revolver maintains shell casing?
Revolvers have a cylinder housing that loads. You have to load each individual shot into. Once that housing is closed into the breech, every fire that trigger, that shell casing is kept in the gun by some mechanism in the revolver.
So what we're looking at here is not a bullet, but a shell case.
Correct.
Found on near the body of Mr. Coleman?
Yes, sir.
Thank you. Go to states 12. Is this a different angle that orients us towards the mask and the body of Mr. Coleman?
It is.
Sir, is there an air pump beside the Charger that you can see?
There is. You can see the hose at the.
Point it out on the TV screen. Yeah, please.
So you can see the air hose right about here behind the trash can.
Okay, thank you, sir. You can take your seat. Sir, did you have an opportunity to look into the car of the victim's car?
I did.
Is this a shot of the victim's car?
Yes, it is.
Can we go to states 15? Is that a shot of the passenger's side car of the victim?
Yes, sir.
So with inside of the passenger side car, on that side, do we have a close-up on stage 16?
We do.
Sir, stage 17, is that the floorboard passenger side?
Yes, it is.
Is there something significant on the floorboard that maybe help us sure?
Yes, there's a second empty gun holster.
Y'all able to determine which kind of gun holster it was?
Not to my knowledge, no. No, not me.
And would you step down and just point onto the TV screen where the second holster was?
It's just right here.
Okay, thank you. Is that a close-up of what you just referred to?
Yes, it is.
Stage 19? Is that being held up by some hand?
It is.
I noticed that they're wearing gloves. Is there a reason why a crime scene would wear gloves?
To keep from contaminating the evidence, we don't know if it was handled by one of the offenders on scene, that was on scene, the victim. They also preserved any kind of touch DNA evidence.
Now, the stage 20 is the final picture of the victim's car. What's that in the back?
I believe it's a booster seat.
For a toddler?
Yes, sir.
Thank you. Sir, are you familiar with, did you have an opportunity to observe the QT video and look at the offender car?
I did.
Did you have a general idea of the classification of that car, what kind of car it was?
Upon looking at the video at first, I couldn't tell, but after Googling, we knew it was a black Mercedes from the video. Looking at the front headlight assembly on that car, we determined it was a E350 Mercedes.
Does the Mercedes E350 have a unique headlight assembly?
It does. It's got two individual bulbs on top on each side, and then there's a single strip below those lights.
So, knowing that you have a Mercedes E350, and knowing the general type, were there any license plate readers that flock from as well?
There were.
Sir, can you tell the jury what license plate readers?
So Flock is a system that we use. We're part of one of the main departments in the metro Atlanta area that uses the system. What they are their stationary license plate readers, which send alerts to officers who have the system open. They're used to notify us that there are stolen vehicles, stolen license plates, individuals with warrants attached to cars driving through certain cross streets, intersections. They also have a search function that allows us to look up suspect vehicles for crimes that we may have a plate for or may have a description of the vehicle.
Was that in fact done in this case?
Yes, sir, it was.
How many black Mercedes E350s were driving around the PT4 this time?
To my knowledge, only one.
And were y'all able to discern the license plate?
I do. I don't recall the numerics, but I do recall it was an Illinois license plate.
I'm going to show you a series of photographs previously shown to the defense counsel. States 21 through 36. Asking if they can look through that. Did you have a chance to look through that?
Yes, sir, I have.
Are those photographs of the suspect vehicle as it relates to this case?
Yes, sir, it is.
Is that from the Flock system?
It is.
Flock, does that automatically record date, times, and locations?
Yes, sir, it does.
Mechanically?
Automatically, yes.
Your Honor, at this time, I tender states 21 through 36, and inside of 21 through 36 is also the business record certification.
States Exhibit 21 through 36 are admitted without objection.
I'm going to direct your attention to and permission to publish.
Certainly.
Thank you, Your Honor. I'm hard of seeing and hard of hearing. Can you make out the license plate that's there on states 21?
Yes, sir. It is CV 90487.
CV is in Charlie Victor 90487.
Yes, sir.
And that came back to a black Mercedes E350 with that green headlights.
Yes, sir, it did.
Date and time that's indicated by flock on this.
It looks like July 9th, 2022 at 22:16, which would be 10:16 in Eastern Standard Time.
For those that are not familiar with military time, how do you how do you know that 22:16 is?
In the morning, 1 through 12, up to noon is still 1 through 12. We know there's 24 hours in a day, so we just keep counting till 2300 and it resets to 0 hour at midnight.
So if I ride at 1 o'clock in the afternoon, we have 1 to 12, and then 2 o'clock, 2 to 12, and that's how we get to 14.
Yes, sir.
So 2216, I believe you said, is 1016 in the evening?
Yes, sir.
And does it also indicate the location where the car was at 1016 in the evening on July 9th?
It hit off a flock camera in Atlanta, looks like Atlanta Police Department. I don't know where Northside and 17 are, but it's in their jurisdiction.
All right, let's go to states 22 and, pardon me. States 22, is this a flock camera just a few minutes later?
I believe it's going to be the same camera, just 1 second later.
All right. And does flock sometimes catch a car more than once?
Yes, sir, it does.
Let's go to states 23. Could you give us the date and time on this one?
This is July 10th, 2022 at 12:18 a.m.
So just a little bit past midnight?
Yes, sir.
What's the location?
Harrison Road and Redden. It's in Redan in DeKalb County.
States 24, flock capture of that same license plate. Could you give us the date, time, and location?
July 10th, 2022 at 12:24 in the morning.
Okay. And location, sir?
Within Tucker Precinct of DeKalb County Police Department.
Sir, states 25. Could you give us the date, time, and location?
July 10th, 2022 at 12:26 a.m. Mountain Industrial northbound at, I'm not sure what EP is, but this is still in DeKalb County.
Yes, sir. States 26. Date, time?
Still July 10th of 2022. However, it's now 2:35 in the morning at the intersection of West Druid Hills in Brookhaven Police Department jurisdiction.
States 27, date, time, and location, sir?
It appears it's going to be the same date, time, and location for 26 and 27.
Yes, sir. States 28?
This is still July 10th, 2022, but at 12:35 in the morning. This time it's at Lawrenceville Highway in Gwinnett County and within the city of Little Burns Police Department.
States 29?
This is, again, July 10th, 2022 at 2:36 a.m. back inside Brookhaven Police Department's jurisdiction.
States 30?
7/10/2022 at 2:38 a.m. I believe NDH is North Druid Hills.
States 31?
July 10th, 2022 at 2:38 a.m. Still in Brookhaven Police Department jurisdiction.
All right. Just a couple more.
Yes, sir.
States 32.
This is 5:21 in the morning on July 10th, 2022. East Metro CID, I'm not sure where that is, but it is not in Gwinnett County.
And it says Turner Hill and Mall Parkway.
Yes, sir.
Okay. States 33.
This is again on Mall Parkway on July 10th, 2022, but this time at 10:47 a.m. Yes, ma'am.
States 34. A few seconds later.
A few seconds later at I believe the same location.
All right. States 35.
This is July 10th of 2022 at 11:26 a.m. This time entering the forum in the city of Peachtree Corners here in Gwinnett County.
And that was at what time?
11:26 a.m.
And finally, States 36.
This is Spalding Drive in the city of Peachtree Corners on July 10th, 2022 at 11:53 a.m.
That particular location going away from QT towards the care camp?
I believe so, yes.
So were you also involved, at some point defendants were arrested in this case. Present when Mr. Huey was arrested, I'm sorry, there, when Mr. Huey was arrested, did you receive his cell phone?
I did receive his phone.
And I'm going to show you States 37. Do you recognize States 37?
I do.
How do you recognize States 37?
This is Mr. Healy's iPhone, which was I gave to Detective Harrison pursuant to a search warrant.
Okay. Thank you, sir. Defense counsel may have some questions.
Sir.
Judge, at this time, we'll take States 37.
Can you object? 37. Hold on a second. Ms. Drake? Mr. Clegg? Okay, States Exhibit 37 is admitted without objection.
Yes. Good afternoon.
Good afternoon, Mr. Lewis. Doing well. How are you, sir?
I'm doing well. Thank you very much. I understood your testimony to be you determined that the vehicle that you were looking for after the QT shooting was a Mercedes 350. Is that right?
Yes, sir.
I'm terrible with pronouns, so I want to understand that you. Was that when you say you, do you mean you, Officer Merkley, or someone else that's better with cars that told Officer Merkley, or was it sort of a collective, people all contributing and you come up with a Mercedes 350?
No, sir. I looked on Google Photos at Mercedes sedans looking for that unique headlight assembly.
Okay, so when you say you, it's you that determined it was a Mercedes 350. Is that fair to say?
Yes, sir.
And once you determined that it was a Mercedes 350, you plug that into the flock camera to see if any flock cameras pick up a Mercedes 350 in and around the QT. Is that fair to say?
Yes, sir.
Now that's the part I want to understand. When you put that information in, are you looking in a half a mile radius, 1 mile radius? What's the radius if that's how it's determined?
So I'm looking at cross streets, streets that I know have flock cameras in directions that the vehicle possibly could have left in. Any kind of turnoffs on that path that could have been picked up on a camera.
Okay, and I want to make sure, I think I understood what you said. I want to make sure the jury understands what you said. Not every traffic light has a flock camera. Is that fair to say?
That's correct, yes.
So it's not as if from the QT we can start going out 4 cameras, 16 cameras, 32 cameras, and actually have every street monitored to see if there's a Mercedes 350 that traveled by a traffic light. Is that fair to say?
That's fair to say,
okay.
Yes.
Is it from the QT there where the shooting occurred? Is it what's the nearest flock camera that you received a hit on?
It would be after you said
either before or after.
So the closest one would be before the shooting which would be entering across from the QT into the forum.
Okay, so when we say the forum, that is, I believe, the 1126.
It's not a trip. I got this to ask one set of questions, and in my mind said, let's ask a different set of questions. So I'm gonna hand this back to you so you can see it.
Refer to the state's exhibit number since it's all admitted. I think it was at 11:26 on the morning of July 10th, 2022, that you have the Mercedes going into the forum entrance. Is that right?
That's correct.
Okay, good. And your testimony is that the forum entrance is directly across the street from the QT. Is that right?
Yes, sir, that's correct.
Do you know what time the 911 call came in?
I don't have the exact time now.
That's fine. But we have the Mercedes, we have the nearest camera to the QT recording the 350 Mercedes at 11:26 in the morning. Is that right?
Yes, sir.
Got you. The first flock camera that captures the Mercedes 350 after the shooting is where? Where's it located?
That information I don't have.
Okay, so you don't have where the first photo of any Mercedes 350 is taken by a flock camera after the shooting in the area of the QT. Is that right?
Not that I've found.
I got you. And I want to make sure I have this part right. So you determine it's a Mercedes. We saying it's a 350. Is it an E350?
Yes, sir.
That's what's messing me up here. I know E, C. That's how Mercedes are classified, right?
Yes.
C, CL, E, G-Wagon, S-Class, right?
Yes, sir.
Okay, so this is a E350, right? Is that right?
Yes, sir. That's
fantastic. So you determine it as the E350. You stick that into the flock. Flock generates this tag number that you located, right? CD90487. Do I have that right?
Yes, sir, you do.
Once you get that license back from Flock, then you ask Flock for any place that the vehicle has crossed an intersection. Is that fair to say?
Yes, sir, that has the camera.
Okay, so that's, and then Flock tells you, oh, by the way, we have these addresses down in Atlanta, we have some addresses in DeKalb. Flock doesn't say, Flock reveals to you. This is the other places where the E350 has traveled. Is that fair to say?
Yes, sir.
Okay, so prosecutor presented it in a sort of chronological fashion from one of the earliest photos that you had before the shooting to the most recent photo that you had before the shooting. Is that right?
Yes, sir.
Okay, but you're only able to determine that after you get the license plate of the E350 that is closest to the QT before the shooting. Is that right?
Can you ask that question one more time?
I think I can. You only end up, Flock only ends up generating all of these prior E350 sightings after you tell it, hey, look for this license. Is that right?
Yes, sir.
Okay, good. Nobody had given you the license. No one had given you the license plate. You had found the license plate based on your requesting any 350s that would have been in and around QT. Is that right?
Yes, sir.
Okay. Are you familiar with all the locations where the flock is located?
Around that area or in general?
That's what I'm talking about, in and around the QT.
Yes, sir.
Okay, so this is what I'm trying to understand. At the point where all of the E350 sightings have been made in Atlanta, in Decatur, and of course here at Town Center, there are no E350 sightings after the shooting. Is that right?
Not while I was searching for them, no.
Okay, fantastic. And there hasn't been any ladder search there hasn't been any other additional information that you received from Flock that says, oh, now that we have some additional sightings here, or additional sightings. Is that fair to say?
Not that I received, no.
Fantastic. So from the time of the shooting till today, right now, these are all the Flock sightings that we have of the E350. Is that right?
That I'm not sure, sir. I know that these are the ones that I found at the time.
Okay.
I don't know in the follow-up if Flock was used to track this car.
Okay, but you didn't get it.
Correct.
Somebody else might have got it. That's fine. As far as all we have is you understand now. You didn't receive any other information about any 350 sightings after the shooting. Is that fair to say?
That's fair, yes, sir.
And all of those really are precursor questions, as crazy as that sounds. What I really want to know, based on your knowledge of Flock camera locations in and around the QT, what likely direction did the E350 take after the shooting such that it wasn't captured by your request for Flock photos of the E350? Do you understand that question?
Yes, sir.
Okay.
It would have had to travel southbound on Peachtree Parkway.
Southbound on Peachtree Parkway. If it travels southbound on does Peachtree Parkway eventually hit Atlanta?
Yes, sir. It turns into 141, which intersects with 285.
Okay. Are there zero Flock cameras from the QT all the way to 141?
At the time of this, there were not.
Okay. Once the vehicle goes on to 141, and that's a straight shot to 285, is that right?
Yes, sir.
Are there any Flock cameras on 141 at all?
Not to my knowledge.
Okay. So post-shooting, as best as you can tell, it probably traveled south because there are absolutely zero Flock cameras from the QT south all the way down Peachtree Parkway 141 to 285. Is that fair to say?
To my knowledge, yes, sir.
I don't have any further questions. Thank you very much.
Mr. Clegg?
My name's Tom Clegg. I just have two questions. You were not the first officer on the scene, but you were one of the first officers on the scene. Is that correct, sir?
Yes, sir. That's correct.
And you were able to observe the body of the deceased, Mr. Coleman, correct?
Yes, sir.
You were able to see the holster outside of the vehicle, correct?
Yes, sir.
You were able to observe the COVID mask outside of the vehicle, correct?
Yes, sir.
You were able to observe a phone, I guess. Was there a phone near the body?
Not that I recall.
Okay, maybe I'm wrong on that, okay. But you certainly observed the shell casing, right?
Yes, sir, I did.
There was a second holster inside the car, correct?
Yes, sir, there was.
So there's no ambiguity. When we talk about the holster outside and the holster inside, those are separate and distinct holsters, correct?
Yes, sir.
And would both of them have corresponded to a 9mm handgun?
I can't tell that from just a holster.
Would both of them have corresponded, if you can tell us, to a semi-automatic handgun?
On the design from the holster, yes.
Now, there was, inside the Charger was found a wallet and a cell phone on the passenger seat, was there not?
Yes, sir, there was.
And were you able to determine who the owner of those items might have been?
I didn't pick up those items and look for identification.
Fair enough, sir. There is a center console in the vehicle, correct?
Yes, sir, there was.
When I say the vehicle, I mean the Charger. When you arrived, both the driver's side door and the passenger side door were open, correct?
Correct.
You actually observed or had an opportunity to observe the video from the QT depicting what had occurred, correct?
Yes, sir, I did.
And you observed, could you see inside the vehicle? Was there a scuffle inside the vehicle, could you tell?
Not that I could determine from the video we had.
Did you have any reason to believe that more than one shot was fired?
No, sir.
where the shell casing was found some distance outside of the vehicle, correct?
Yes, sir.
There were no shell casings found inside of the vehicle to your knowledge, were there?
No, not that I could see.
There were no actual firearms found at the scene, were there?
Not to my knowledge, no.
Based on the fact that the shell casing was found outside of the vehicle as opposed to the inside of the vehicle, it is reasonable to infer that the shooting took place outside of the vehicle, correct?
Yes, sir.
You can see two individuals appearing to be in a confrontation outside the vehicle immediately before the shooting, can you not?
Yes.
Both of them are standing up at that time, correct?
No, sir. If I remember correctly, they come tumbling out of the car. The victim never has a chance to stand before he's shot.
Okay, so they were either one of them standing, or were they both on the ground, or what?
One was standing and Mr. Coleman was trying to stand at the time he was shot.
Okay. And how far would they have been from one another? Do you recall?
Within a couple feet.
You speak up a tad. Please.
Within a couple feet, sir.
A couple feet. And if you can help me out, when you say a couple feet, how far is a couple feet?
2 to 3 feet.
Okay. Now, if you would come down off the witness stand very briefly. Just stand here. You are obviously significantly involved. And I'm just going to bend your knees a little so you're fighting. You don't need a microphone, okay? Okay, there we go. So, did you ever see, based on what you can see, the two people this close to one another in the video or face to face? Okay. And so, one of the guys is standing up, right? And is he erect? Standing all the way up? And so the other individual is face to face in the video, right? Right. So he's literally face to face, right? Okay, gotcha. Okay. Just to make sure we understand each other, it is not a situation where one person is standing up and the other person is literally on the ground like this.
Not to my knowledge, no.
No. Okay. Now, one shot is fired, correct?
Yes, sir.
And there is no blood. There is obviously a lot of blood at the scene, right?
Yes, sir.
The body is approximately, what, 8 to 10 feet from the driver's side of the door?
About, yes.
There is no blood found inside the car, is there?
To my knowledge, no.
There is a lot of blood in the immediate vicinity of the body, correct?
Yes, sir.
But distance between the car, the front door, driver's side door of the car, and the body, there are 7 or 8 feet or so where there is no blood, right?
Correct.
Most of the blood is consistent with the victim having been shot, fallen immediately, and then having bled from that location, correct?
Yes, sir.
You saw the clothing of Mr. Coleman, correct?
I did.
Did you see any sort of rips or tears to his clothing?
No, sir, I did not.
Did you collect any of the items? There's the COVID mask. Did you collect that?
Personally, no, that was collected by our crime scene technicians.
As well as the shell casing, correct?
Yes, sir.
As well as the, I guess the mask.
The holster?
Shell casing, and what else? There was 3.
The holster.
Okay. Were the holsters identical in one another?
They appeared similar.
Okay. The clock situation, Mr. Lewis has done a fairly thorough job of clarifying the situation regarding the flock, but let me just see if I understand a few things. First off, going back to the scene and watching the video of the black sedan, appears to be a Mercedes leaving the parking lot. You cannot see a tag number, can you?
I can't see the numerics now.
You can't tell any numbers or digits or letters or state of origin, correct?
Not off the numbers and digits.
Okay. But at some point you are looking for what you believe to be a Mercedes E350, right?
Yes, sir.
Specifically black, correct?
Yes, sir.
find that such a vehicle has been located in the general area, correct?
Yes, sir.
And the block system enables you, once you get a tag number, to figure out where that car has been for a period of time, wherever there are block cameras, correct?
Yes, sir.
Now, if I'm understanding correctly, the QT on Peachtree Parkway, I don't know. So, if you get off on Peachtree Industrial, it's a car comes over. Does that split off and one of it becomes Peachtree Parkway and one of it becomes Peachtree Industrial?
Yes, sir, it does.
And Peachtree Industrial comes to the left or the right?
Peachtree Industrial goes off to the right.
Okay, so Peachtree Parkway goes to the left, correct?
Yes, sir.
And how many miles are there between the QT on Peachtree Parkway until it intersects with Peachtree Industrial, aka 141?
Best estimate is probably 5 miles.
And then once you get on 141, how far is it to 285?
Maybe another 10 miles.
So the QT to 285 is 12, 15 miles, is that right? Or is that back on the wall?
It's 12 miles sounds about correct to me.
Your testimony is that there is no flock camera anywhere between the QT heading south on either Peachtree Parkway or until it intersects with 141. Is that correct?
Correct. Not directly on Peachtree Parkway, but not directly on Peachtree Parkway that would capture vehicles going southbound or northbound, but on branch off streets where you would turn off Peachtree Parkway there are.
But there are flock cameras pretty much anywhere and everywhere else, right?
Yes and no. I'm not the one who determines where flock cameras are placed.
Well, I mean, you and Mr. Melvin went through a lengthy list of photographs, and you started with, I think, photograph number 21, State's Exhibit 21. Could we see that on the overhead projector or on the screen, please, sir? Mr. Melvin and Mr. Thank you. 21. Okay, now this photograph, this is State's Exhibit 21. I need to see the time and I need to see the location. Okay, this is taken at 10:16 in the evening on the 9th of July, correct?
Yes, sir.
The homicide occurs on the 10th of July at approximately 12:40 or so in the afternoon. Is that a fair approximation?
Yes, sir.
Now, this photograph is taken at Northside Drive, right?
Yes, sir.
You know where Northside Drive is?
I do not.
Is it in the city of Atlanta as far as you know?
From what the flock information states, this is a Atlanta Police flock camera.
At the bottom of the photograph here, it says Atlanta Police Foundation. Is that consistent with being taken in the city of Atlanta, right?
Yes, sir.
Okay, now let's go to number 22. This is a few minutes later again on Northside Drive, right?
It's about 1 second later.
Oh, 1 second. Oh, there we go. And again, still city of Atlanta, right?
Yes, sir.
Number 23. This is Hairston Road and Ravine, I guess it's 12:18 a.m. right on the 10th, right?
Yes, sir.
The homicide in Gwinnett occurred at approximately 12:40 p.m., correct?
Yes, sir.
And this is in DeKalb County, right?
Yes, sir.
You know where Hairston and Ravine are, right?
An approximation.
Stone Mountain area, right? Okay, next one. Page 24. This is then at 12:24 a.m. This is in Tucker, right?
Yes, sir.
That's in DeKalb County, right?
Yes, sir.
How far is Tucker from Peachtree Parkway?
I'm not sure. It's
Going back to the dam in North Harrison. How far is that from the QuikTrip on Peachtree Parkway?
I'm not sure, sir.
Fair enough. Next picture, State's Exhibit number 25. This is Mountain Industrial of Tucker, right?
Yes, sir.
This is 12:26 a.m. on the 10th, right?
Yes, sir.
And it says Tucker Summit CID. What does CID stand for?
It's my understanding it's Criminal Investigative Division.
And again, that would be a DeKalb County location, correct?
Yes, sir.
Next one, 26. Now, this is Brookhaven, correct?
Yes, sir.
And this is 2:35 in the morning on July 10th, right?
Yes, sir.
This is West Druid Hills, somewhere, I guess, there too, or 85, right?
Yes, it says towards I, which would indicate towards 85.
Okay, and you know where Brookhaven is, right?
Yes, sir.
That is in DeKalb County, correct?
Yes, sir, it is.
Not far from the Fulton County line, in where Fulton and DeKalb meet, correct?
Correct.
And West Druid Hills, I mean, you know where Druid Hills is, right?
Yes, sir.
Again, how far is that from the QuikTrip on Peachtree Parkway?
It's a distance.
We got that.
It's a distance.
It's a distance, I understand it's a distance. Can you offer a specific estimate to the distance?
No, sir, I cannot.
Okay, 27. And here's another one on West Druid Hills, right?
Yes, sir.
28. Lawrenceville Highway, right?
Yes, sir.
This is in Gwinnett County, right?
Yes, sir, it is.
Middleburg, correct?
Yes, sir.
Lawrenceville Highway is nowhere near Peachtree Parkway, is it?
It's on the opposite of 85 for us.
Okay. And this is at 12:35 again on the 10th, correct?
Yes, sir.
29. This one is Brookhaven. North Druid Hills, is that what that means?
I believe so, yes. I believe so.
Again, nowhere near Peachtree or Parkway, right?
No, sir.
Go ahead, next one. Next 30. Holly Lane, Brookhaven. Do you have any idea where Holly Lane is?
I don't, sir.
Does it look like there's North Druid Hills at Holly Lane?
It appears to be a cross street, yes.
Gotcha. And again, nowhere near Peachtree Parkway, right?
No, sir.
31. Again, same thing, Holly Lane, North Druid Hills, okay, 32. Turner Hill and Ball Parkway. Do you know where that is?
No, sir, I do not.
Okay, have you ever been on I-20?
Briefly.
You go on from, if you get to 285 and then go east on I-20 towards Augusta, you know where the, mall, I can't remember it, not South Carolina, the mall out in, the Lycoming here. Are you familiar with that particular mall?
No, sir, I'm not.
Fair enough, so no problem. But you don't know where Turner Hill is, right?
No, sir, I do not.
Okay. 33. Now, this one is taken again on the 10th at 10:47 a.m. And again, we're talking about the Mall Parkway. That is consistent with the location apparently in State's Exhibit number 32, right?
Yes, sir.
Okay, it says East Metro CID on each of the photographs, does it not?
Yes, sir, it does.
Okay, go to 34. Again, at 10:47 a.m. Same location, East Metro CID Mall Parkway, correct?
Yes, sir.
Same location, same approximate location as 33 and 32, correct?
It appears so, yes.
Okay, 35. And this is the former entrance card, 1126.
Yes, sir.
And 36. This is 1153 Spalding Drive, correct?
Yes, sir.
How far is Spalding Drive from the QuikTrip?
Less than a mile.
Okay. Now, that is approximately 50 minutes or so before the homicide, right?
Approximately, yes.
Okay. And from that time on, even though there is apparently a flock camera across the street from the QuikTrip, we never see this vehicle again, correct?
Not on flock, no, sir.
Not on flock. So, despite that there have been, doing the math here, I guess 16 pictures of this vehicle captured over a period of about 12, 14 hours in Atlanta, in Tucker, in Coleman, in Lithonia, and in Brookhaven, there is nothing after the fact unflocked, right?
Not that I found, no, sir.
Now, you are concerned not so much about where the car was beforehand, but where the car was after, right?
Yes, sir.
And there again, flock is supposed to be an aid to enable you to see where the cars might be, right?
Yes, sir.
And you can see the car here, there, and everywhere in the 12 to 14 hours leading up to the homicide, right?
Yes, sir.
But the time when the homicide actually happens, lo and behold, flock magically is unable to capture a single photograph of that particular license plate anywhere. Is that your testimony?
If it doesn't drive past the camera, we don't get a picture of it.
I don't have anything else. Thank you for coming, sir.
Yes, sir.
Great.
How are you?
Good, how are you, Ms. Drake?
I am good. I always try to use proper titles. If I end up calling you officer, I am not trying to be disrespectful.
Certainly. Move around the courtroom if you don't need to request that. You said 2, 3, and 4 exhibit?
Don't worry, I'm not going to ask you a question without giving these back to you. Sometimes it's just easier for me to pull them out and then ask you about them than trying to go through. And Madam Court Reporter, may we steal these from you? Thank you. Steal's not a good word. We're going to politely... apologize to everyone. Just wanted to take a little bit of time here. May I approach again, Your Honor?
Absolutely.
I'm going to show you what's already been admitted as State's Exhibit 6, which is a picture of Mr. Coleman outside of the vehicle. In State's Exhibit number 6, is there any blood between his foot and his paw?
Not that I can see.
And was that the position you found him in when you arrived?
Yes, ma'am.
And let me go to another picture. I'll try to put these in order. I'm terrible at getting them out. I just want to clarify, State's Exhibit 9, which has been admitted into evidence. Oh, I'm sorry, thank you. State's Exhibit number 9. Was that the one that was found outside the holster?
Outside the car, yes, ma'am.
And State's Exhibit number 13.
Both of the car doors are open. Is that the way the car appeared when you arrived?
Yes, ma'am.
And I believe this is going to be the last one, States 15. In States 15, is there a shoe located in the floorboard of the passenger side?
Yes, ma'am, there is.
Was there another shoe in that picture that you can see?
It's going to be under the back passenger side door.
And I'm going to point to it. Is that what you're referencing?
Yes, ma'am.
And those appear to be one of a pair, each of them matching shoes?
Yes, ma'am.
And where was the casing in relation to Mr. Coleman's body?
I believe it was closer to his feet.
And about guns, if a bullet is ejected, doesn't it normally go backwards to the right?
It's more to the right than backwards.
Okay, but to the right.
To the right, yes, ma'am.
I'm going to show you what's been marked and shown to the state as defendants exhibits 2, 3, and 4. If you would just take a look at those. And let me know when you're done. Do you know what defendants exhibit 2 is?
2 looks like a print off of what would have been the CAD call at the time.
And can you please explain to the jury what is a CAD call?
So CAD stands for Computer Aided Dispatch. It is inputted by our 911 operators to give us information before we get to the scene, give us an address, the signal for what type of call we're going to. In this case, it's a person shot call. It notes date, time, and once something's been entered into the CAD call, it can't be deleted.
And does that indicate that you were dispatched or that you were involved in this CAD call?
It does.
And does it appear to be alternating?
No, ma'am, it doesn't.
Your Honor, I would tender into evidence defendants exhibit 2.
All right, defendant's exhibit 2 is admitted without objection.
And before I start asking you questions, if you would please look at defendants 3 and 4. Defendants 3 and 4. And if you would compare 3 to State's Exhibit 35, and then defendants 4 to State's Exhibit 36. And please let me know when you're done. First, do you recognize what defendants 3 and 4 are?
Yes, they're block photos.
Are they copies of what is States 35 and 36?
Yes, ma'am.
Is there any difference other than one appears to be an original color and the other one is a black and white photostat copy?
Not that I can see.
Your Honor, at this point, I would tender into evidence defendants 3 and 4.
All right, defendants exhibits 3 and 4 are admitted without objection.
And if you would, sir, I'm going to take defendants 3 and 4. And if you would refer to 35 and 36 to make it easier. But I do want to ask you a question. On defendants again?
It has the time the call was created. I'm not sure if it's the time the 911 call came in exactly, but it's close.
Okay, and what
I'm
time
gonna,
would
I'm
that?
gonna ask you to speak into the microphone to
I'm
make
sorry,
sure.
Your Honor.
It's okay. When you turn, then we don't catch your voice. Okay.
Yes, ma'am.
So this was created at what time, sir?
12:39 p.m.
And 52 seconds. It gets down to the actual milliseconds. And that was 12:39 in the afternoon.
Yes, ma'am.
And what date was that?
That was July 10th, 2022.
So the last two photos that we have of the Mercedes 350 with the tag CB90487, if you would look at States 35, which you said corresponding to Defendants 3, the time on that is what, sir?
A little over an hour before the call was created.
And that time is at 11:26 a.m. Would that be a fair statement?
Yes, ma'am.
And that is directly across from the QT.
Yes, ma'am.
And then if you would, please look at Defendants 4. And where is that from?
This is one intersection down from the QT,
And what time was that?
11:53 a.m.
And how long before the call was created on the CAD report were they already away from the foreman, whoever they were in that car?
According to this, about 50 minutes.
And I wanted to ask you just a little bit about your search, because I don't believe that you and I have discussed this. When you look for something on Flock, are you just seeing the back of the car, or are you seeing the front of the car?
Just the back of the car.
The particular car that you saw when you reviewed QT video, did the headlights appear to have any alterations to them?
They did not.
Now, without seeing specifically the car on Flock, you cannot say whether there were modifications made to the headlights on that particular car. Would that be a fair statement?
I can't tell from the flock cameras, no, ma'am.
And when you're searching for these particular headlights, did you keep going until you found one that matched?
Yes, ma'am.
So how many different types of cars did you look at?
I compared whatever Google put up on the screen to whatever E-Class or whatever black Mercedes sedan showed up in the Google search.
Did you look at the E450 by chance?
I don't recall.
If I can have just a moment, please.
Sure.
That's all I have. Thank you, Detective.
Thank you, ma'am.
Mr. Miller?
Just wanted to recross. Officer Berkeley, Ms. Drake asked you, that's all the flock pictures we got, but there may be more flock pictures involved in this case that are not before you. Is that correct?
That's correct, sir.
And let's talk just a second about the queries of flock. Did you query flock?
Send a search through it?
Yeah, when you were talking about flock earlier, how do you actually say what car you want to go for flock canvases?
So you can limit your search if you don't have a license plate or a tag for the vehicle. You can search it by make, color. It doesn't get specific to model, but you can limit down the search to what exactly you're looking for.
And when you figured out that it was a Mercedes E350, did you enter that query the date and time around this month?
It gets only specific to black Mercedes sedan. When I found this one that we determined was an E350, that's when I found this car.
That's what I want to do on. So when you found this one, when you entered black Mercedes E350, How many automobiles came up?
Just this one.
Thank you.
I thought I understood that the first time, but I also understood you said
That there are absolutely 0 flock cameras from the QT all the way down to 285 on the particular road, Peachtree Industrial, is that right?
Peachtree Parkway, 2 Peachtree Industrial.
Peachtree Parkway, I got you. Thank you very much. How long are the flock photos preserved? Do you know?
I do not. I don't know how long flock keeps them. I know I can search for a car as far back as 60 days in the settings I have for the application.
Okay, and typically you ask for the largest search when you're doing this type of search where there's a shooting. Is that fair to say?
It depends on the time frame. In this immediate area, a search of 1 to 2 days, because we know the shooting occurred with this vehicle. I'm not looking for whoever drove this car 2 months beforehand.
I got you. So your search may have been limited to basically 48 hours. Is that right?
Yes, sir.
The prosecutor's asking about potential other flock videos. Were you aware that any other law enforcement officer ran a flock request for the same E350 license CV 90487?
I'm not sure what officer may or may not have.
Thank you very much.
When you ran your search, you would have gotten all possible flock hits for that particular vehicle that you were searching. Is that a correct statement?
Yes, ma'am.
And what we have here are all of the flock videos that you received when you input that information.
For this particular tag, yes.
Okay. Okay.
Are there flock cameras on here?
Not to my knowledge, no.
Is there any sort of surveillance system that captures vehicles on video?
The only surveillance that I know of would be live feed cameras from DOT, but they don't record.
Okay, thank you very much.
Sure.
All right, no more questions. We'd ask that Officer Murphy be excused. No objection. Thank
you very much, Mr. Officer Murphy, and you can stay in the courtroom or go back to your place of business.
Thank you.
Thank you. Does the jury need a comfort break? You good? Okay.
Okay, we would call crime scene technician Kelly Benz. K-E. Vince, you can take that.
Good afternoon. If you will remain standing and raise your right hand, do you swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth? Thank you very much. Please be seated.
Good afternoon, Ms. Spence. How are you doing today?
Good, how are you?
Doing good. Thank you so much for being here. Ms. Spence, can you introduce yourself to the jury?
Yes, my name is Kelly Bentz, and I was a crime scene investigator with Gwinnett County during the time of this case.
Well, as a crime scene investigator, what kind of training did you have that qualified you for that?
I have a bachelor's in investigative forensics, as well as on-the-job training and additional certifications, specializing in each individual kind of specialty within the forensic umbrella.
Ms. Spence, did you actually respond to the QT here in Gwinnett County in order to process the murder scene, at least the homicide scene of Bradley Coleman?
Yes, I did.
I'm going to walk you through a series of photographs and direct your attention to previously admitted to states 6 through 20. Give me is that one of the pictures that you took?
Yes, it is.
So we have yellow markers here on the TV screen. And could you walk us through what these markers delineate?
So the yellow markers are evidence markers. Evidence markers are utilized for items of evidentiary value that were pertaining to that crime at the time.
So I want to walk you just through a couple of them. And in particular, I'd like to, and I'm going to pull up onto the screen, previously admitted states 10. States 10 has evidence marker 2 decided. Was that there at the crime scene when you were out?
Yes, it was.
Did you actually not only take a picture of it, but also take it into physical custody?
Yes, I did.
What did you do with it once you took it into custody?
So I secured it in a locked crime scene truck as I continued to process the rest of the scene, and then I took it back to the crime lab where obviously it was processed for further evidence.
So I'm going to show you some physical evidence in addition to the photographs that you see there. And direct your attention to what's previously marked as State's Exhibit number 39. You recognize the evidence file for State's 39? I want to stay in.
Yes, I do.
If you'll excuse me, I want to stay in.
Okay.
State's 38. Okay. You take a second to look at that. You recognize State's 38?
Yes, I do.
Okay, State's 38. What is State's 38? Contained in the evidence bag of State's 38.
It was a firearm holster that was on the ground near the head of the deceased, Bradley Coleman.
So we've seen 2 firearm holsters photographs. One was beside the body, one was inside of the car. Which one is State's 38?
38 is the one that was by the body.
State's 39. Can you direct your attention to State's 39? State's 39 is an evidence bag. What's contained within State's 39?
This is the black firearm holster that was on the front passenger floorboard.
Did you personally put those in those evidence bags?
Yes, I did.
Judge, we tender States 38 and 39 this time.
States 38 and 39 are admitted without objection.
Shell casing located at the scene, Ms. Bennett? I'm going to hand you what we previously marked as States Exhibit 40. You recognize the evidence bag of States 40?
Yes, I do.
What is contained within the evidence bag of States 40?
It was a fired cartridge casing, 9mm in caliber.
Is that the cartridge case located near the body of Mr. Coleman?
Yes, it is.
Take that, place it into States 40?
Yes, I did.
Judge, we tender States 40 this time.
States Exhibit 40 is admitted without objection.
Ms. Bennett, I'm going to direct your attention to evidence bag that's labeled States 41. Do you recognize this evidence bag?
Yes, I do.
How do you recognize that evidence bag?
It is the disposable face mask that was laying on the ground within the apparent blood that's on the screen.
Yes, sir. The picture on the screen is States 10. Is the contents within that bag, the mask that's located in States 10?
Yes, it is.
And you place that in the evidence bag?
Yes, I did.
Judge, we tender States 10 this time.
States Exhibit 41 is admitted without objection.
I want to go back and cover States 41. When you took that COVID mask and placed it into the bag, how did you secure the bag?
So I sealed it, and it was secured inside the crime scene truck when I was on scene processing.
So do you do that with every piece of evidence sealing into the bag?
So if it's going to require further processing on my end, it will just be secured in a brown bag and take back to the crime scene unit. But again, my crime scene truck is locked while I'm on scene, and the keys remain with me.
I'm going to show you what's previously marked as States Exhibit 42. Do you recognize States 42?
I do not.
I'm sorry.
I think these are the swabs.
I'm sorry?
These are swabs that were taken from the mask.
Swabbing is taken from the bag.
Yes.
from the massive slaying and evidence by 641.
Yes.
So, Judge, we tip stage 42 this time. 42.
42 swabbings from the mask. Ms. Drake. All right, State's Exhibit 42 is admitted without objection.
Right. Ms. Spence, thank you. Defense counsel may have some questions.
Yes.
States 42.
Yes.
That was simply by reading what's on the outside.
That is correct. My initials are on my seals.
And has that bag been opened?
Possibly by the next set of initials that's on here.
Let's talk about that for a second. Whenever you place something into an evidence bag, may I approach the witness, please?
Yes.
Whenever I see there's a bunch of,
You're fine.
red tape. What is the purpose of the red tape?
To seal the bag and for you to initial and date.
Why do you do that?
So that you can show that you were the last person that handled that evidence.
Why is that important?
So that you can establish chain of custody and make sure that nothing has been tampered with.
So in looking at States 42, are your initials on this bag?
It is not.
And I'm just comparing for purposes. States 40, does that appear that your seal has been broken at all?
This is the, yes, for processing. So this is another initial and seal. This is my original seal.
So when someone breaks the seal, they are supposed to initial.
Reseal and initial.
So States Exhibit 42, has that seal been broken from what was originally placed inside?
I have no idea.
Are there more than one sets of initials on there?
So for what I can see, there is one.
And you don't actually know what's in 42 from your own personal knowledge. You're just reading what's on the outside of the package.
That is correct.
That's all I have.
No further questions asked. Ms. Spence, please.
No objection.
Thank you, Ms. Smith, Ms. Spence, and you're excused. Okay, thank you. Do you expect Dr. Terry to be an hour or?
The next one might take a little bit of time, Judge.
Okay.
You have to wait 10 minutes.
Comfort break? Okay, let's have a comfort break before we start our next witness. Is that our last witness of the day, Mr. Melvin? Okay.
Possibly squeeze it.
Okay, great. All right, thank you. All right, I'm assuming Dr. Terry's running late.
She's not running late, Judge.
Oh, okay. It's all right. It's all good.
Yeah, Judge.
And I had these out. We're not opening those.
No, not right now.
All right.
Judge, I just want to put something on the record because although Ms. Nettinger's next, I think we're going to go immediately into Dr. Terry. All the pictures from Dr. Terry are going to be pre-autopsy, pre-incision autopsy, but there's one post-autopsy.
Okay.
It's going to be stage 51, which is the lung.
Lung.
Right, the Coleman, which is full of blood.
Okay.
Since it's post-autopsy, I want to look at the court note in case there was an issue.
Okay. Thank you very much, Mr. Melvin.
And if the court needs to see it, I'm happy to present it.
And no, I'll see it if there's an objection. Yeah, yeah. Okay. Are we ready for the jury to come back? Yes, Mr. Clegg. Ms. Drake. Mr. Melvin.
Yes, ma'am.
Okay. Now I'm waiting till the last.
Yes,
Mr.
yes,
Okay.
yes, Judge.
All right. Bring him back. Always wait for. Okay. State, call its next witness.
State will call, and Your Honor, I'm going to call a witness out of order, so the exhibits are going to be different order.
Sure.
She has a personal matter. State calls Kelsey Nettinger. Ms. Nettinger, go ahead.
Standing on the podium and raise your right hand. Do you swear or affirm the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth?
I do.
Thank you very much. Please be seated.
Ms. Nettinger, if you'll introduce yourself to the jury.
Hi, my name is Kelsey Nettinger. I'm a crime scene specialist for Gwinnett County Police Department.
How long have you been a crime scene specialist with the PD?
About 9 years.
What training do you have that qualifies you for that?
I have a Bachelor's of Science in Criminal Justice. I'm also have completed an FTO, that's a field training program with the county upon getting hired. I'm certified by the state as well as by the International Association of Identification.
Now, there are crime scene specialists that are brand new, and then there's supervisors. Where do you fall?
I'm the most senior of the specialists themselves, the ones that actually work the field.
Did you get involved in the state of Georgia versus David Booker, Miles Collins, and Josiah Hewley?
Yes.
For an incident that took place at QT hearing on July 10, 2022?
I did.
What's the nature of your involvement?
I was requested by a detective to take photographs, obtain a beautiful swab, and elimination prints of one of the defendants.
I'm going to show you a series of photographs on states 56 through 64. Ask if you're familiar with this particular
photograph. Did you say 56?
Yes, ma'am, through 64. Yes, ma'am. Did you have an opportunity to take photographs of defendant Josiah Hewley?
Yes, I did.
And states 56 through 64, are those in fact the photographs that you took?
Yes, they are.
True and accurate representations of how Mr. Hewley appeared on July 10 or July 20.
Yes.
Your Honor, this time we'll tender states 56 through 64.
States exhibits 56 through 64 are admitted without objection.
Thank you, Your Honor. I'm going to publish those at a different time.
Okay.
You indicated to the jury that crime scene technicians also obtain what's called buckle swabs. Talk to us about that.
Yes. Buccal swabs are swabs. They're essentially sterile Q-tips that are placed inside of your mouth. They're swabbed against the cheek, and then that way we can obtain a DNA sample.
Did you do that in this case?
I did.
Did you do that for defendant Josiah Hewley?
I did.
The issue was previously remarked the state's exhibit 65. Do you recognize those 65?
Yes, this is the buccal swab that I obtained from Josiah Hewley.
It's an evidence bag containing that?
Yes.
Okay. And when you actually obtained it and placed it in the evidence bag labeled State 65, how did you secure it?
I secure it with evidence tape and then with my initials.
Mr. Millman, is that 66? 65, okay.
I have 65.
Okay, I just want to make sure I've got 65 as a picture, forearm picture.
Oh, I'm sorry, Your Honor. That's going to be my mistake. If you don't mind, buccal swab.
Absolutely.
Thank you.
65 is buccal swab of Mr. Hewley.
Once that is sealed, what happens with State 65?
That item is entered into a program called SAFE, which gives it a barcode and a label, and then it is transported to the evidence unit. It's secured there, and its chain of custody is followed via that barcode system.
Can we talk about the chain of custody of the PD for just a few minutes? When something is put into police department evidence, how is it secured? Can anybody get to it?
No, there's cameras and locked doors and the whole 9 yards.
Is each piece of evidence logged in and the PD have a unique identifying case number?
Yes, they do.
What was the unique identifying case number for this particular case?
This one is GP 2200-56130.
That's right. That's all the questions I have.
All right.
So State's Exhibit 65, did you seal that in any way?
Yes, with the red tape and my initials.
And why do you do that?
To make sure that no one else can tamper with that evidence.
And has that seal been broken?
No.
And you stated that you took elimination prints. What are you referencing?
Elimination prints are prints that are requested by the actual detective to take inked prints from somebody that is known. So you have latent prints. Those are prints that are obtained from a scene in which you do not know who those belong to. Whereas inked elimination prints are prints that I directly take from an individual. I know exactly who they came from, so that way they can be compared to other items that are unknown.
So if anything was tested for fingerprints, they would be compared to what you took from a certain individual to see if they match or don't match.
If there are any latents that were obtained, but also obtained with value. They have to have value and be clear and enough of a print to be compared to those prints. Yes.
And where did you encounter Mr. Hewley whenever you did this?
I was requested to respond to the CID room. It's at Gwinnett Police Headquarters and in the interview room.
And was that pre-interview or post-interview?
I don't recall. It's usually afterwards, but I can't be specific towards it. I just respond as soon as I'm requested.
And do you know if those interview rooms have cameras in there?
Yes, they do.
And do they have audio in there?
Yes, they do.
Okay, thank you. That's all I have.
No further questions. We ask that this lady here be released from the school.
All right, thank you very much. You are released. Now you can get the bottle of water, Eddie.
Your Honor, and I apologize because of the speed of the witness. Dr. Terry is underway.
Okay.
She's 10 minutes.
Okay. All right, that's...
She will not be much longer in this room.
Okay. All right, why don't we just stand at ease so y'all don't just have to sit there. Terry's 10 minutes out. So Eddie's getting has twice now gotten her cold water. So let's just let the jury be at ease till Dr. Terry gets here, because she might need to have a minute to collect her file. Okay. Y'all can go on back to the jury room. All right, ladies and gentlemen, I think the state is going to call its last witness for today. Is that correct, Mr. Melvin?
That's correct, Judge, but before I do, I'd like to tender state 65.
You did the buccal swab. Yeah. You did. I've got you tendered it, and it was admitted without objection. Is that what y'all got?
Yes, Judge.
Yeah. No, it was Mr. Hewley's buccal swab.
64.
Oh, 64 was the, I don't know, because I have,
64 is a photo, 65 is buccal swab.
I've got those wrong. I mean, I've got, right. Yeah, you did tender it.
All right.
Yeah. Huh? Okay, absolutely. Will you tender it again?
Yes, ma'am, I tender state 65 this time.
It's, okay. The state 65 is submitted without objection. Thank you.
So I'm going to get back on track. We'll call Dr. Carol Terry.
We've got you some cold water. And a pointer. Will you just perfectly warm? You raise your right hand. Do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please be seated, Dr. Terry.
Thank you.
Dr. Terry, thank you for joining us today. Could you introduce yourself to the jury, please?
I'm Dr. Carol, that's C-A-R-O-L, Terry, T-E-R-R-Y.
Dr. Terry, what is your current occupation?
I am a forensic pathologist. I function as the chief medical examiner for Gwinnett County.
Dr. Terry, what background do you have that qualifies you to hold that position?
Okay. In 1986, I graduated from Emory College of Emory University with a double major. I have a Bachelor of Arts in Religion and a Bachelor of Science in Biology. From 1986 to 1990, I attended Emory University School of Medicine, where I received my Doctor of Medicine degree, so I am an MD. From 1990 to 1995, I did a 5-year residency in the area of pathology. It was a combined program of anatomic and clinical pathology. And it was in the Emory University affiliated hospital systems. So that involved working in hospitals like Grady Memorial Hospital, Emory, the VA Hospital, then Crawford Long, and Eggleston Hospital. My combined program of pathology broadly stated is the study of disease, and the 5-year residency involved the areas of anatomic and clinical pathology. Anatomic pathology is tissue-based pathology and involves diagnosing disease states from tissues, like biopsies or organs or tissues removed from living people, as well as autopsy specimens. Clinical pathology is the laboratory medicine aspect of pathology and involves diagnosing disease states from fluids like blood, urine, saliva, etc., and involves such areas as chemistry, hematology, microbiology, and blood banking. Now, during the last year of my 5-year residency, I keep saying 5 years, it was 5 long years. Last year of my 5-year residency, I was allowed to work exclusively at the Fulton County Medical Examiner's Office in a subspecialty of pathology, forensic pathology. Forensic pathology is the medical legal investigation of death. And in doing forensic pathology, we as medical examiners are tasked with investigating deaths that are reported to us under the Georgia Death Investigation Act. And so these are deaths that are sudden, unexpected, unexplained, or due to non-natural causes. And so I spent the last year of my residency doing that.
Following the completion of my residency in 1995, I did an additional year of training in forensic pathology, also at the Fulton County Medical Examiner's office, and this year of training outside of the residency is referred to as a fellowship year. And because I already had a year of experience in that office, I was essentially treated like a junior attending and got to supervise other individuals who were rotating through the office. Following the completion of my fellowship year in 1996, I stayed on staff at the Fulton County Medical Examiner's office as an associate medical examiner. And I kept that position until I left in 2004. In 2004, I went to work for Dr. Gerald T. Gowitt, and that's G-O-W-I-T-T, who's the chief medical examiner in DeKalb County. I was an independent contractor for Dr. Gowitt, and not only did we handle medical examiner cases for DeKalb County, but we also covered medical examiner cases for Hall, Henry, Rockdale, and White counties. Toward the end of 2005, Dr. Gowitt made me aware of the upcoming opening of the medical examiner position here in Gwinnett County. The medical examiner position in Gwinnett County is a contracted position, and so I had the opportunity to form my own company and put in a bid for the medical examiner contract here. I was awarded that contract in February of 2006. It comes up for renewal every 5 years. I have maintained that contract since February 2006. So as I said, I function as the chief medical examiner for Gwinnett County. It is not a county department. It is a contracted position. Everyone who participates in death investigation in Gwinnett County is my employee under that contract. I have personally, in my career, conducted between 6,600 and 6,700 autopsies. All told, I've examined over 10,000 bodies in my career, because not everybody gets an autopsy. Some bodies get what we call external examinations, where we just do an outside examination of the body, especially when there's obvious trauma and specimens drawn for perhaps drug testing or other types of chemical analyses. I've supervised individuals in an additional 700 or more cases through my work at the medical examiner's office in Fulton County. I'm licensed to practice medicine in the state of Georgia and have been since 1992. I'm triple board certified by the American Board of Pathology in all 3 areas of pathology in which I have trained and studied: anatomic, clinical, and forensic pathology. And I have been tendered as an expert witness in the Superior Courts of Georgia over 435 times.
Your Honor, this time we tender Dr. Terry as the pathology expert.
So tendered.
Dr. Terry, did you have an opportunity to conduct an autopsy of one Bradley Coleman?
Yes, I did.
Dr. Terry, I'm going to show you a series of photographs previously shown to the defense counsel, the states exhibit 40 through 51, and ask you to just take a moment to familiarize yourself.
Okay.
Do those photographs accurately represent the condition of the body of Mr. Coleman? At least states 43 through 50, the condition of Mr. Coleman's body before you perform the autopsy.
Well, it's during I consider the external examination part of the autopsy. So once I start examining the body, that's part of the autopsy. But those exhibits you just mentioned are prior to any opening or cuts being made on the body, yes.
Do they contain findings or at least indicate things that are relevant to the cause of death?
Yes, they do.
Judge, at this time we would tender states 41 through 53. Dr. Terry?
States exhibits 43 through 51
Yes, ma'am.
are admitted without objection.
Dr. Terry, I'm going to pull them up on the TV screen, and I would ask, if you could you step down and let us go through the pictures together so that you can explain to the jury the significance of the findings.
If I may. Thank you.
Dr. Terry, could you talk us through when a body does come to you, what do you do? I see some things about this picture. Oh, I'm so sorry.
Well, at this point in time, the body has come into the morgue. I have discussed with the investigators who's handled this case what the reported circumstances are. So he is giving me his synopsis of what occurred. And in this case, my investigator went to the scene. So he had actually been to the scene. He's the one who put the bags on the hands to prevent any potential evidence that might be there on the hands. He's the one who made sure that the body is appropriately positioned in a disaster bag or body bag. There's a tag and a seal, so you see the liquid bag. And in this photograph, what you're seeing is the bag has been opened. There's been no manipulation of the body by me at this point in time. And this is how Mr. Coleman appeared when I first saw him. And so these are the articles of clothing that he's wearing. You see the wire here. He has an identification tag that's on his leg, placed there by my investigator who was at the scene. And you can see how he was dressed at the scene. And so this is how he appeared when I first saw him.
Dr. Terry, I'm going to pull up and what's been previously entered as States 64. Could you describe anything significant?
Okay, what we're looking at here, this is the top of Mr. Coleman's head on the left side, and this is prior to any cleaning of the body. So this is dry blood here. We can see sergeant injury there. We don't see it well because hair is around it. And so, again, this is prior to cleaning of the body and prior to my shaving around this wound. Because before I looked at this wound, before any water or washing it between the first and the shave the hair around it so that I don't lose the visual evidence if you watch that.
Dr. Terry, it's at a point like this, if you had had what's called a press contact wound, would that be obvious at this point?
No, not necessarily, again, because we're dealing with an area that's covered by hair.
Is that a closer up view of what we've just described?
I don't know if it's closer up, it's about the same picture.
Oh, I'm so sorry. Can you describe what we're seeing here? And I'm going to see if I can flip this. What's that, Judge?
In this photograph, what we're looking at is, again, Mr. Coleman prior to being addressed, prior to being cleaned up. It's a front of the bag, under the hand, it's under the foreground. One is mainly showing this here in front of the neck. There's another hole or defect. This actually corresponds to what's going to be the exit wound. What we're seeing on the top of the head is going to be the exit wound. We'll get a good look at it. And this is going to be the exit wound.
Dr. Terry, I apologize. I hadn't talked to you about this, but
The entrance wound is here, the exit wound is here, the orientation is the gun is here. And the gun, if you stop me with the angle, the entry would be consistent.
I'm not there.
You view the gun and I would.
Right, or I can't tell you about
Can the jurors see that? If you need to stand up, or Mr. Melvin, why don't you go toward Eddie?
Sure.
Why don't you, because the jurors in the back can't see.
So this would be the position of Mr. Coleman on the fatal shot.
Position of, well, this head relative to the gun. If I'm standing like this, I can't tell you exactly how or necessarily position. I can tell you about the relationship of the body to the gun. And the wound half is going downward, and it's going up from the back to the front, slightly toward the right. One of these directions I'm talking about, this is left and right, and back and front. And we haven't discussed this yet, but it is a loose contact range wound, so ultimately that is up against the head and it's discharged.
I'd like to zoom in. At this point, Dr. Terry, could you describe what this picture is demonstrating?
Okay, in this photograph, we're looking at Mr. Coleman's head, as indicated, shaded around the room. The entrance wound could be here. You can see a little bit of the dark just around it. It's part of it caused by the soot. There's a laceration from here that extends through this wound. There are various slight abrasions and a little bit of bruising on the face, the nose, and the bruising in the forehead. And in this photograph, it's been cleaned up. You can see that there's been shading around the room. You can see the edge of quite at this point yet, but again, it's traveling from up down, so it's a downward trajectory, going slightly from the front, on the back towards the front, and slightly from the left towards the right.
You described soot within the injury. How does soot get within an injury like that?
It comes out of the muzzle of the gun. When a firearm is discharged, things other than bullet come out of the end of the gun. You have gases, sometimes flame, as well as soot or smoke, and particles of gunpowder.
How close do you have to be to a firearm
To have what?
to have soot within an injury like that?
It depends on the firearm. It depends on a number of factors, such as the caliber of the weapon, firearm, type of the ammunition, things of that nature. So for me, as a medical examiner, I choose a qualitative term. I'll say it's contact or close range. And looking at beyond an area where there's no longer soot deposited, but I've got gunpowder, and I call that medium range. So because of there being variability based on parameters that are associated with the firearm and ammunition, issues that are handled by a ballistics examiner who best fires weapons and can tell you what these precise ranges are. Typically for me, when I see soot, it's usually inside of a foot. But when I see a wound like this, I've got soot, I don't have stippling, which are injuries caused by gunpowder. Everything that's being discharged out of that firearm is going into that hole. And the soot is a little dispersed. This is a loose contact. It's not a press contact where I have a muzzle injury. It's loose contact. The gun is a loose fracture.
Okay, the picture that's been pulled up there, is there anything significant around the mouth?
Oh, well, you see a little bit of frothy, bloody fluid.
What's that indicate, Doc?
So in this case, it's because I've got a breach of the airway. There's a disruption of the airway, and blood is getting mixed with air from the lungs. And you see subsequently, but he did continue to breathe after receiving this gunshot wound, and I've got evidence of what's called blood aspiration, where blood has been inhaled.
Space 53, what are we looking at?
We're looking at the left lung here. The left lung has two lobes. There's the upper lobe, the lower lobe, and we see this splotchy in there, or purple area. That's where blood has been inhaled into the lung. It's more consolidated here, more fluid. And again, this is indicative of the person breathing after receiving this gunshot wound.
Doctor, I think we have one other photo as well, and this is the close-up of the neck. What is significant to you about this photo?
This is a close-up of the neck that's not been cleaned up, but this is the incident that there's not any kind of abrasion or scraping around it. Again, it's got some clotted blood here. What's significant is it's the incident. I've got an entrance wound. I haven't seen really a good picture of it.
Oh, I'm sorry. And there's the entrance wound being the one that was shaved, correct, Doctor?
Correct.
That right there, that entrance wound?
Whether it's the entrance wound, there's a better picture of it. Here we go. All right. This is the entrance wound. The entrance wound is typically round to oval. As I said, this one's got some lacerations, ears extending more by it. But the main entrance defect is right here. It's relatively round. It's got some abrasion or scraping around the end. And then we've got this dark ring of sweat around it and no stippling.
Dr. Terry, thank you so much. You can take your seat. I just have a couple of final questions. How quickly would death come with the injury that you just saw?
With this type of injury, most likely pretty quickly, I'd say seconds to maybe minutes. I know it was not an immediate death because of the inhalation of blood. So there is some breathing in to account for that amount of blood within the lungs.
Thank you, Dr. Terry.
You're welcome.
Ms. Drake?
I don't have any questions, thank you.
You're welcome.
Do we release Dr. Terry? All right, thank you, Dr. Terry.
Thank you, Your Honor.
Good.
Thank you.
Have a good evening.
You too.
Thank you. All right, ladies and gentlemen, we're going to adjourn for the evening. Let me find my... You are not allowed to talk to anyone about this case, including your fellow jurors, your spouses, anyone at home. You're not allowed to research this case, look it up on social media, news sites, websites. Try to avoid TV and any kind of news about this about this case until you deliberate. Please don't post anything on your own social media about you being on this jury, and we will see you tomorrow at 8:45. Thank you very much and have a great evening. Any matters from the state that I need to take up before? Any matters from the defense that I need to take up? All right, we are off the record. Thank you.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the voices that won't